in terms of deciding when to prosecute and when not to prosecute. Let's just expand a bit on that.
That is the essence of our application. It's twofold. We're saying that the NPA has got a discretion to institute criminal proceedings as outlined in the Constitution, as well as to decide not to institute. In this matter, we're saying, in line with our policy directives, we are saying that our decision to stop the proceedings is based on solid factual basis, as enunciated in our policy directive, that a prosecutor who is tainted in terms of the processes, the prosecutorial processes, cannot actually take the matter to court. That is the principle that must be outlined today and be addressed by the SCA. Further, we are addressing the issue of separation of powers. Remember, the Pretoria court said the charges must be reinstated. We're saying that it is not for the court to instruct the NPA. It must just refer the matter back to the NPA for reconsideration.
And those are some of the issues that will be ventilated in court. I see that the justices have walked in and the proceedings are currently underway. Let's go straight into the courtroom.
Please, the court justices. I appear for the first respondent, the DA, together with Mr. Duval, Mr. Borgstrom and Mr. Vakele.
Mr. Epstein, housekeeping matters first. There is an application for condemnation which I understand the parties are agreed should be granted in relation to the filing of the record.
That is so, Madam.
No consequent orders, just the condemnation.
No consequent, no cost issue.
No cost. Is that agreed?
Yeah, that's agreed.
Second, the Chambers voiced our collective displeasure at the state of the record before the core bundle was filed. We have all worked on the main record, and so our references will probably be in relation to the main record. But I do think that an apology should be forthcoming in relation to the state of the record, because it's repetitive, it's a bit chaotic.
Yes, well, justices may unconditionally apologize for the state of the record. As an excuse, but not as a justification, we were granted leave after Zuma was granted leave, and we had to piggyback on the record which was being done. But it's not a justification. It should have been done, and we apologize.
Did you consult with Mr. Kemp at all in relation to the production of the record?
The State Attorney consulted with Mr. Kemp's attorneys in regard to the production, and in fact they called the compiler of the record, the services attending to it, called me from time to time.
Liability?
I think Mr. Kemp would, I didn't liaise with Mr. Kemp, but I tried my best with the transcribers.
Perhaps we should hear from him.
Justice Nafsa, on behalf of the applicant on the cuisine, I apologize for the state of the record. It was a difficult task. It could have been done better. It should have been done better.
Yes, very well. Well, perhaps condemnation is granted in respect of the filing of the record. Perhaps we can now move to the minutes. And the other thing we agreed is that in relation to the application for leave and the merits, we'll argue all at once.
As the court pleases, we will argue that there are compelling reasons for granting leave to appeal and that the prospects of success are not remote, but we of course have to first address the court on what those merits are.
An appropriate starting point would probably be, Mr. Epstein, the statement by Mr. Mshe.
Which is?
The statement by Mr. Mshe as to the
Yes.
reasons, the means.
Yes. Well, before I get there, I mean, we've...
You're going to have to speak up, Mr.
Yes.
Epstein. The acoustics aren't that good.
Yes. So we see the essence of this matter, and the central issue is whether the conduct of McCarthy was so egregious and the process so tainted that it was not in the public interest and the integrity of the criminal justice system to pursue the prosecution. And the question, therefore, is whether the decision taken by Mshe was rational. That, of course, is the central issue. Now,
For you, the chief protagonist is Mr. McCarthy.
Yes, he was. Justice Nafsa, I'd like to deal up front, if I may, but obviously according to your direction, with the issue in our additional heads, and that concerns the power used by Mshe when the decision was
Yes,
taken.
it's a convenient place to start, and I referred you earlier in chambers to the decision of the Constitutional Court in the Liebenberg matter.
Yes. And Justice Nafsa, I've looked at the case, and it doesn't make the task easier in terms of distinguishing the present situation from the precedents and the cases.
Could I understand, perhaps we can agree on what the law is,
Yes.
and then we can look at the facts. As I understand it, if a decision maker refers to the wrong empowering statute, but in fact acted under the appropriate one, then the ensuing decision is not invalidated.
Yes, I think that's it.
Okay, so we agree on that. What the Constitutional Court seems to be saying in Liebenberg, and I know you sought to distinguish Harris, but Liebenberg in fact refers to Harris, does it not?
Yes.
Now, as I understand that, is if you mistakenly act under empowering statute X or the section of the Constitution X, when in fact you should be acting under Y, that does invalidate things. That seems to me to be
that's the problem which I need to distinguish. It's a problem we've raised because the matter proceeded from inception on the basis that the decision was taken in terms of section 179(5)(d), which is a review, and we know that this court has said that a national director cannot review a national director. And in the papers it was said that McCarthy took the decision, but this court also said in 2009 that Mshe took the decision. So he could not review, and we accept that he could not have reviewed his own decision.
Well,
But what he could have done is he could have reconsidered his decision. So there's a review where you review a deputy public prosecutor, that you do in terms of 179(5)(d). He was reviewing his own decision. He couldn't do that. We accept that.
Well,
but he could reconsider.
Could we just step back factually to what Mr. Hofmeyer's position is? Mr. Hofmeyer's position was the contrary to what you're putting now, isn't it? Mr. Hofmeyer's situation was we tried to keep him apart from the decision. So it was McCarthy who made the decision. And the reason we did so, let's not intrude upon the space of the multi-tiered nature of the decision. Let's leave that aside for the moment. But as I understand what Mr. Hofmeyer says is, he says McCarthy made the decision because we wanted to insulate Mr. Mshe, who later had to review it. So that's the position he adopts, which basically must mean factually, and I think we all proceeded on that basis because Mr. Mshe makes, I think, a confirmatory affidavit, but yes. We all operate, everybody appears to have operated on the decision that it was a review of McCarthy's decision.
Yes, they did. But I'd like to accept and endorse what you say, Justice Nafsa. The problem is this, that in the 2009 decision, the review there was opposed on behalf of the NPA on the basis that Mshe could not have been reviewing a decision of Nuka or Picoli because they were national directors.
Are you talking about the decision by Justice Harms? Are you talking about the decision by Justice Harms?
Yes, that decision.
Yes.
So there the court finds it was a decision of Mshe, and there the court finds that he could not have reviewed a decision of another national director. And Hofmeyr says in his affidavit, clearly the decision was taken by Mshe in terms of 179(5)(d). He says that. I can't move away from that. So what then happens, he says, but in fact, although he ultimately took the decision, it was a corporate decision, which Mr. Downer called it. And they were all involved in taking the decision. And even if it is a corporate decision, he can't review his own decision. So in fact, he then explains that it was McCarthy who was running with us. He was the lead prosecutor, and therefore McCarthy took the decision, and it could be reviewed.
Could we look at the permutations, the factual permutations? You're bound by what Justice Harum said, and I think that's the basis on which you did the supplementary hits. So that's the one immovable that you have. On Mr. Hofmeyer's position, well, McCarthy took the decision.
Yes.
But at some stage, on the permutations, even as per Mr. Hofmeyer's affidavit, Mr. Mshe was party at some stage to a discussion.
Yes, that is so.
So isn't it dispositive and a real mountain for you to climb? Because if the law is as we agreed it is in Liebenberg, then if you're bound by what Justice Harum said, then Mr. Mshe was mistaken as to what he was doing, because the whole insulation submission by Mr. Hofmeyer is that he must have been thinking he was reviewing a decision of Mr. McCarthy. That's, so factually, whatever the permutations are, you're in trouble.
Well, Justice Nafsa, that is so. I realized that when we were preparing for the case. That's why we put in the additional heads. It was my duty and incumbent upon me to inform the court of this difficulty. So one leg has been cut off. I think I've got another leg to stand on, which may be an attempt to try and distinguish it. We tried to distinguish Howick, and I would like to just try and distinguish Liebenberg if I can. The problem is this, that if I, at risk of repeating myself, the difficulty is this, or these are the possible permutations. Either Mshe reviewed a decision of McCarthy, which he was entitled to do, or it was a reconsideration in terms of 179.2, although he thought he was acting in terms of 179.5d. And the affidavits say that.
Sorry, you're going too quickly. Could you just repeat the last two submissions you were making?
So the only basis upon which Mshe could act in terms of section 179.5d was if he was reviewing a decision of McCarthy alone, not a corporate decision, because otherwise he was party to that decision. Now, in fact, the NPA advanced argument to this court in 2009 in the Harams DP decision, on which Justice Kachalia sat as well, that it was Mshe who took the decision. And that was central to that case, because in that case, Zuma was arguing that he was entitled to the benefits of section 179.5d because it was a review in terms of that section. And the court said it can't be. You cannot have an NDPP, Mshe, reviewing a decision of former NDPP.
Could I ask you this? As I understand the basis of your submissions in the supplementary heads, is that, and that's why you made them, because you considered yourself bound by what Justice Adams found, along with my brother Kachalia and 3 other members of this court. So you considered yourself bound by that.
Yes.
That's why you made
that
it.
Is so.
Now, if that is so, and the submissions or the factual basis on which Mr. Hofmeyer says the decision was arrived at must mean that the decision is wanting for, particularly on the basis of what Liebenberg says. But you've got another problem, even on your permutation of it being a collective decision, which it appears at some stage on Mr. Hofmeyer's to be, because Mr. Mshe attended the meetings, he was briefed, they had meetings with Mr. Downer, they had meetings with Mr. McCarthy. Even on that permutation, you have a difficulty with the Constitutional Court judgment.
In fact, it goes further against me, because the whole idea of that review is that you give somebody who's applying for a review an objective view. Now, if he's taken the decision as part of a corporate decision, he could not be objective. Mr. Hofmeyer said at page 301 of volume 2, the NDP...
Sorry, just give us a second. 301.
301, paragraph 657.
Can you at the same time give me the core bundle reference, please? The core bundle reference.
Oh, the core bundle, that is the core bundle reference. So all my references
so
are to
all your
bundle.
references to the core bundle.
Okay, well, now we've got a problem. If you give us the paragraph.
It's paragraph 657. 301. Volume 2 of the core bundle at 657.
657. Okay, I have that.
So this is Hofmeyer's affidavit. He says the NDPP's power to review a decision to prosecute is regulated by section 170, that's a typo, should be 179.5d of the Constitution, read with section 22.2c of the NPA Act. The scope of this power is explained in paragraph 75 to 77 above. The NPA respondents contend that Mshe acted in accordance with what section 179.5d and section 22.2c of the NPA Act.
Well,
I can't move away from that.
Well, doesn't it go further against you in that if you look at what Mr. Hofmeyer said in respect of Mr. Piccoli's decision, he said, well, he couldn't make the decision. It should have been a decision of a DPP. So he bolsters it. I'm sorry to do this to you, Mr. Epstein, and you very correctly, as an officer of the court, made the concessions you've made. But isn't it dispositive? I mean, if for that reason the decision is tainted, then you don't have a decision to withdraw or to stay the prosecution or not to continue with it. Where does that take you? Then the only question is, subsequent to that, the only question then is whether, as you complain and as Mr. Kemp complains, you can't order the prosecution, and then that's a debate about whether or not the earlier decision remains extant. But aren't you bound, aren't you limited to that?
Well, I am subject to my trying, in a moment, if I may, to distinguish it.
Sure.
If I can't distinguish it, if the court's against me on that, then I would have to ask for an adjournment to see if I can get an earlier flight.
Well, could I just say this to you? It's whether or not it is distinguishable.
Yes.
From Liebenberg.
That is so.
Okay, very well. Make your best effort.
So if I may take you to our additional heads where we try to distinguish it.
I think it's where you refer to Harris, isn't it?
Yes, so we make the reference to Harris. The point about Harris is that in that case, the Minister of Education used a provision in an entirely different statute. He used a provision in the Policy Act, whereas it was only available to him in the Schools Act. And the Constitutional Court and Justice Sachs said, well, if you find your power in a particular statute and a particular act, you can't rely on another one simply because it is available to you. Now, there's reference in the Harris case to Latib and the decision of Gelgajay, and at paragraph 8 of our additional heads, we quote the relevant portion where Gelgajay said, "It seems clear, therefore, that where there is no direction in the statute requiring that the section in terms of which proclamation is made should be mentioned, then even though it is desirable, nevertheless there's no need to mention the section, and further that provided that the enabling statute grants the power to make the proclamation, the fact that it is said to be made under the wrong section will not invalidate the notice." And in the Howick District landowners matter, Cameron J. explained Latib as follows: when empowering statute does not require that the provision in terms of which a power is exercised is expressly specified, the decision maker need not mention it, provided, moreover, that the enabling statute grants the power sought to be exercised. The fact that the decision maker mentions the wrong provision does not invalidate the legislative or administrative act.
Well, could I ask you, whilst we're addressing that, to turn to paragraph 93 of the Liebenberg judgment? And I thought we'd agreed that this is the law, but let's just go through it a little more carefully. Before addressing the question, it is useful to make one observation. In our law, administrative functions performed in terms of incorrect provisions are invalid. That seems to me to be what we've agreed. Yes. Even if, and the same would apply, I would assume, to non-administrative actions, for example. The functionary is empowered to perform the function concerned by another provision. Even if, so, yeah, even if Mr. Mshe was entitled to do it under another provision, the fact that he purported to do it under one provision which wasn't the empowering of the proper provision would make it invalid.
Yes, I accept.
So far, so good.
No.
In accordance with this principle, where a functionary deliberately chooses a provision in terms of which it performs an administrative function, but it turns out that the chosen provision does not provide authority, the function cannot be saved from invalidity by the existence of authority in a different provision. Now, let me say this. You've sought to distinguish Harris on the basis of different legislation. This is about provisions in one statute. At least that's the way it's spelled out. Am I correct in that?
You are, Justice Nathan.
Okay. Then 94 is the only thing that can come to your rescue. So let's look at it. The general rule admits of only one exception. This is where it is clear from the facts that the functionary had elected to rely on the correct provision, but mistakenly referred to an incorrect provision. Now, Mr. Epstein, with the best will in the world, aren't you hamstrung?
Yes, it's clear from the affidavit he intended to rely on 179.5d, quite clear. Perhaps the distinguishing factor is that he wasn't required and did not, when making the statement, state that he's making it in terms of 179(5)(d). So you've got a section of the Constitution, section 179, which gives powers of reconsideration. Prosecutors can reconsider their decisions, and there's a power to reconsider in terms of a review. Now, as a prosecutor, in terms of section 22(9), he, as notwithstanding he's the national director, can prosecute. He can then reconsider his own decision. So the question is whether, in terms of 179, the function he was performing was the same. It was called it a review or reconsideration, but the function was the same.
Well, let me just understand this. We've agreed what the law is. On Mr. Hofmeyer's affidavit, can there be any doubt on your affidavit, your client's affidavit? And it's a yes or no answer, and this one can't avoid. Can there be any doubt on Mr. Hofmeyer's affidavit that what he was doing is he was reviewing Mr. McCarthy's decision?
On Hofmeyer's affidavit, Mshe was reviewing Mshe. He says so.
No, but doesn't he
301.
say he wanted to insulate because it was Mr. McCarthy's decision?
He says it's McCarthy's decision, but it's a corporate decision. He's privy, he's party to that decision.
No, he says principally the person who made this decision, and he refers wrongly, he refers to the decision, to that email from Mr. Downer. Do you recall it? It's in the supplementary affidavit,
yes,
where he says, well, we discussed who should make the decision.
Yes.
And Mr. Downer then says, well, it's for the DSO to make the decision.
Yes.
And Mr. Hofmeyer, I'm afraid, is emphatic that that's the whole reason why they did it. And Mr. Hofmeyer contests this corporate decision. And I think, as does Mr. Kemp's heads, that the DA relies upon.
He explains, he says it was blurred. Before, when the matter came before Haram's J, he said it'd be blurred. He said it's unfortunate that it was mischaracterized. But he said it wasn't really Mshe's decision. It was he was part of a corporate decision.
Well,
let's just be quite clear, because we're dealing with the affidavits here, and we have to have regard to both the affidavits and what was found in the 2009 decision, right? Now, there, Mshe and Hofmeyer deposed to affidavits where they said that the decision made was that of McCarthy and Mshe together. Correct?
Yes.
And it was on that basis that this court found that that Mshe had made that decision under purportedly under section 179(5). Right. What then happens is, in this case, contradictory affidavits are put up by the same people. And in these affidavits, they now seek to distance themselves from what they said under oath in the 2009 case. Because what is now being contended is that, in fact, the decision was McCarthy's, and that he manipulated Mshe. Yeah. In fact, it goes further and says at the crucial time, Mshe went on holiday.
Yes.
So the point of the matter is, here are people who deposed to affidavits, both Mr. Hofmeyer and Mr. Mshe, to contradictory affidavits, totally contradictory affidavits, in 2 hearings. Now, the question is this: that being so, and given the fact that the decision, the Haram's decision in 2009 would have been before the decision makers when they made this decision, which is the subject matter of the present review, is that not an indication that that Mshe and whoever else made the decision, after deposing to these affidavits, absolutely were not applying their minds at all to the material before them? Surely they would have had to have looked at the very decision which has now come back in relation to the 27th, 28th December indictment. That's my problem. So even if you overcome the issue around whether they mistakenly used the power, the next question is whether they applied their minds at all, having regard to the fact that contradictory versions have been put up.
Well, Justice Kachalia, when the matter was realized in preparation for this, after our initial heads had been filed, because our initial heads relied on 179.5D, I took instructions from Mr. Sean Abrams. He said, regardless as to what has gone before, it doesn't matter. He wasn't party to it. He wants the correct position placed before the court.
Well,
and that's what we've done.
Could I just ask you to go to page 334 of the main bundle? I'm afraid I've worked on the main bundle. It's volume 3. Para 67. Let's start at para 67 and read it.
I'm sorry, Justin, that's the volume CB3. Core bundle 3?
No, not core bundle. Main bundle.
And the main bundle.
Paragraph, well, it's paragraph 67. If you can find Mr. Hofmeyer's affidavit, you go to paragraph 67. We're going to have to read 4 or 5 paragraphs together.
At the time of the Zuma prosecution. That's
right. So could we read it together? Because there are about 5 or 6 paragraphs in tandem that both impinge on the point that we were debating and that the issue raised by my brother Kachalia. At the time of the Zuma prosecution, 2 people in the DSO had the necessary authority to institute the prosecution. The first was McCarthy. This has got to be seen before I go on against his attitude that Piccoli couldn't institute the prosecution. The first was McCarthy, the head of the DSO. The second was Mgenge. So he's saying those are the only 2 people who could institute the prosecution. The investigating director responsible for the prosecution, Mshe, had no power to make the decision to prosecute Zuma, nor did he purport to do so. Okay? Next paragraph. I need to point out that in the previous litigation, which is what my brother referred to, the question had been blurred. I draw this court's attention to paragraphs 92 and 93 of Duploy's affidavit. This affidavit was made pursuant to an application by Zuma to set aside the 2007 decision to charge him. Zuma claimed that the decision was invalid because he was not given an opportunity to make representations. Then he goes on to what Duploy said. And Duploy said, at the end of para 92 of Duploy's affidavit, if you turn to the next page, which is my page 335, do you have that?
I've got in Duploy's affidavit.
Yes. So it's para 92 of Duploy's affidavit. He says, this process of drafting, consultation and assessment was completed by 11th December, whereupon Mr. Mshe and Mr. McCarthy considered the matter as a whole with a view to taking a decision on prosecution. This is what Mr. Hofmeyer says on the next page, para 69.
But before that, if I can interrupt for a moment,
yes.
At the bottom of 93 of Duploy's affidavit says, Mr. Mshe accordingly issued the instruction to the prosecution team to reinstitute the charges without delay.
So he's saying Mshe is directing matters.
Yes.
All right. The next paragraph, which is paragraph 69, says, this is not an accurate record of what happened. This is Mr. Hofmeyer. These are your papers. It is correct that McCarthy, accompanied by the prosecution team, met with Mshe to consider the NPA's response to the SCA decision. However, what is not recorded is that Mshe made it clear that all decisions about the prosecution should be left to the DSO. And it also is not correct that Mshe made the decision to institute the prosecution on the 27th. And as my brother pointed out, Mshe was on leave at the time. It was McCarthy who decided it should be done before the end of 2007. Now, Mr. Epstein, you said before that very correctly Mr. Abrams said, well, let the cards fall where they may, we've got to adopt the correct position. Well, you did indicate earlier that you might want to take an instruction on where you go with what we had. Now, on this particular issue, I think you acknowledged right at the beginning it's a very steep hill for you to ascend. Is that correct?
Yes, Justin, I've said. In fact, on that basis, it would be a procedurally irrational. If not substantively irrational, then it's procedurally irrational.
Well,
it may well go to substantive irrationality as well, because if contradictory versions are put up, then it goes to the heart of the very decision that was made, not merely the procedure that was adopted. The material before the people who are putting up affidavits or the people who are making the final decision now must include perforce Deploy's affidavit, the Harem's judgment. All of those matters are before the decision maker. So is it merely procedural irrationality, or does it go directly to the question of the state of mind of the decision maker?
Well, the basis of the decision is that the conduct of McCarthy was so egregious and so tainted the process that it did not allow for a continuation of the prosecution. And so that fact, whether it was a reconsideration or whether it's a review, that fact wouldn't change. They were still acting in terms of a consideration of how egregious is this, what kind of interference is this, and what manipulation is this.
Well, but as I understand it, on the debate we've been having up until now, and very technically, because you've always been proper technically, Mr. Epstein, if I might compliment you on that, I don't know how you get past the first point. I don't know how you even get, I mean, it is substantive, because that's what the judgment of Justice J in the Constitutional Court says. It transcends into a substantive point. It has a substantive effect. If you purported to exercise a power X, when in fact that wasn't the power you had, isn't that the end of the matter, substantively? I'm putting that to you, and no. I think the answer is yes or no.
Justice Navsa, I feared so. All I could try to do was to try to distinguish the case from the present one. And I know it's a difficult climb. The Liebenberg case is pretty clear. The only argument I could submit is that it's a reconsideration. They're applying their minds in terms of the same section, whether they're doing the 179(5)(d), where they would have been entitled to get representations, or whether they're doing it as a prosecutorial reconsideration. The facts that they have to apply their minds to would be the same.
Well, let me put to you finally, and perhaps we must now draw this part to a close, and I mean, you might want to take an instruction on it, because I think on the facts you have a difficulty. So the distinguishing is one thing, but the facts, I don't know if the facts give you any room for maneuver. But Mr. Hofmeyer adopts the position, and he's adopted consistently, that he was concerned about legality, he was concerned about propriety. He says that repeatedly. Now, if he's concerned about that, and he does this on behalf of your clients, then you must be as concerned as you are now about the matters that you raise pertinently in relation to the supplementary heads. And therefore, for consistency, you would expect that they would say, okay, this is a mess. We're sorry we made a mistake.
Well, Justice Navsa, I'll have to rest my case there. It's taken 8 years to get here. It's been a long journey, and I'd like to address you then on what happens. Does it go back for a decision in terms of the rights provision?
Well, can I ask you this? Are you now giving up the ghost in relation to the correctness of, well, you're now, given what your supplementary heads did, given the debate that we've had, having regard to Liebenberg, are you accepting that you are now left? Mr. Kemp may adopt a different position, that's neither here nor there, but all that's left to you is that you've now got to persuade us that the court below, when it said charges will have to be faced, was entering upon the terrain of another arm of government.
Yes.
Is that?
That is so. Justice Navsa, it's quite clear to the justices and to everyone that there is this difficulty. If you're asking me to concede it, I'd like to advance the argument I have, for whatever merit it may have, to distinguish it and leave it.
You don't say that with much conviction, Mr. Epstein.
Well, not with much conviction, but the cases are difficult. Justice Sachs said in the Harris case, the applicability of this line of reasoning must depend on the particular facts of each case. And perhaps the facts in this case are somewhat different because it's the same decision and the same provision. But if you'd allow me to,
Yes,
to leave it there.
very well.
Mr. Epstein, because Mr. Kemp, Mr. Kemp still has to come, and the DA still has to argue, I want to explore another problem with you, and that is assuming you overcome the 179 problem. You then faced with, as I understand your case, it's this. It's not the decision to prosecute that was contaminated. It was the decision when to serve the indictment that was contaminated. Correct?
Correct.
Now, this court ruled and held emphatically in the 2009 case that the motive for the prosecution is irrelevant. If the prosecution is brought even for an improper purpose, provided that its principal purpose, the principal purpose of the prosecution is to secure a conviction of an accused, whatever other extraneous factors may operate are really irrelevant. That was the clear finding in this court. Now, I struggle to understand that if that is, as we stated the law then, how it can possibly argue that the prosecution isn't contaminated when the decision is not attacked, but merely the date when the indictment is going to be served is attacked. That I have great difficulty with.
Now, Justice Kachalia, let me make one aspect clear. Perhaps I should have said it at the outset. There is no contention on behalf of the NDPP that...
Speak up, please, Mr.
There is no contention on behalf of the NPP that there, in regard to the merits, that there is not, if not a strong case, at least a prima facie case against Zuma. That's never been the contention in this matter. Nor has it ever been the contention that Mr. Zuma would not receive a fair trial. The only contention is that when you have conduct of the prosecutor who's running the process, and that conduct is so egregious, it is so manipulative, and the purpose is to manipulate the outcome of not an ordinary election, but an election as to who would become the president of this country, then the court says that abuse cannot be tolerated. The message which must be sent out to the public is that anybody who is prosecuted will be prosecuted fairly and without an ulterior motive, which is different, Justice Kachalia, from the ill motive which you spoke about. You can prosecute somebody with an ill motive. It doesn't make the case bad. And you can prosecute somebody with a good motive. It doesn't make the case good. But there's an ulterior, there's an ulterior motive, and this was the ulterior motive, to take the prosecution process, which was ongoing, in progress, and to take that and to now stop it and to use it to manipulate who would become the president of the country.
The process culminating in the decision to prosecute was over.
That was over.
That was over by the end of November. Between the beginning of December and, let's call it Polokwane, which was the 16th of December, they were getting authorization under POCA, they were finalizing the indictment. So the decision had been made, assuming in your favor that the abuse is established, and if we have to go there, we'll have to debate the facts with you as to whether in fact that was established. But assuming in your favor, for present purposes, that it's established, all that is established was that somebody interfered with the date when the indictment was going to be served. It had nothing to do with the decision to prosecute.
It is accepted. Downer said, when he listened to the tapes and he heard what was going on, he said he was reduced to tears, but he still wanted to carry on with the case. Now the question is, even though there is the decision to prosecute at the time is not tainted, If during a prosecutorial process it is established that there have been shenanigans, for want of another description,
no, but what
that
I'm
people have
putting to you is that the
misbehaved.
process was over. The prosecutorial process was over. It was in the crossing of the T's and the dotting of the I's, the date when they were going to formally serve the indictment, that there was a debate whether this should happen before Polokwane or after Polokwane. And I'm saying to you, what I'm putting to you is simply this, that assuming in your favor that some people, including Mr. McCarthy, had bad motives for delaying it till afterwards. And I must tell you on the facts, Mshe also had that view after having spoken with Minister Mabandla. So there was a confluence of ideas and views on that matter. But let's leave that aside. I say again, assuming in your favor, the process was over at the end of November. So your argument must be that the mere serving of the indictment for a bad motive, in this case, was good enough to nullify the entire prosecution. That must be your argument. And what I'm putting to you simply is this: in the light of our judgment in 2009, on what basis can you possibly advance that submission?
Justice Charlie, I think the conduct shouldn't be minimized. I mean,
before you answer that, can I just put my problem to you, as my learned brothers put to you? The decision had been taken to prosecute. Mr. Sheikh had been convicted. There'd been a finding of some relationship between Mr. Zuma and Mr. Sheikh. There were now a few additional charges that were being considered and were included ultimately in the charge sheet. So the decision to prosecute had been taken. And then, what difference can it make as to when, in that regard, as to when the indictment is actually served? Because once you've taken the decision to prosecute, there's no abuse thereafter of the prosecutorial process. It's not a question of you are prosecuting someone for an improper purpose. That decision had already been taken, and that's the essential difficulty that I have, that I share with this whole thing, as to why, when you find out that there's been some discussion with people that maybe there shouldn't have been a discussion with, this should so embarrass the prosecutorial authorities that the prosecution should be withdrawn.
Well, Justice Leach, can I answer first by looking at how serious was this conduct? And there are three passages I would like to refer to. The first is that the DA, in its own papers, and right at the very beginning in Core Bundle 1, at page 94, these are their founding papers.
So is this Mr. Self's?
This is Mr. Self's affidavit.
Is that should be in volume 1 of the main?
Volume 1 at paragraph 94.
94, you said?
Paragraph 94, Justice Kachana. Now, Mr. Self says, to the degree that Mr. McCarthy was a party to manipulating the timing of exactly when Mr. Zuma was to be recharged, that is to say, whether this should occur before or after the ANC's national conference held in Polokwane during December 2007, this was plainly most irregular and worthy of strong criticism. In the next paragraph 96, he says, in the fourth line, again, the irregularity of Mr. McCarthy's conduct is not to be minimized.
No, but go back to para 95. Para 95 is what my two brothers have been putting to you. Read para 95.
That deals with improper motive.
Well, no. However, in the context of the matter as a whole, the absence of any proper tainting the decision to charge and to recharge that had been conducted by a committed and dedicated team of prosecutors. But as you rightly pointed out, if you go to page 121 of volume 1, this is what you pointed out. Page 121.
Paragraph, Justice.
Well, page 121 is the statement by Mr. Mshe in volume 1. So if you look at the statement by Mr. Mshe, which sets out why he chose.
Yes, I have that, Justice.
Well, in the middle, under background, in the middle of that page, more or less line 12, 13, The representations submitted pertain to the following issues: the substantive merits, the fair trial defences, the practical implications and consideration of continued prosecution, the policy aspects. And then he says, I need to state up front that we could not find anything with regard to the first three. So the substantive merits, I think you indicated, you considered was good.
Yeah.
Mr. Downer was particularly strong in his memorandum about that. The fair trial defences, he says, well, that won't impinge. The practical implications of continued prosecution, he doesn't think that will impinge. And he really does it on the basis of policy, and it's really about McCarthy relating to the timing. So if you go to all of the cases that we were referred to, the foreign jurisdiction cases, particularly the English cases, those really impinged on fair trial considerations and irregularities. But again, it's a trial judge's discretion, is it not, in weighing up those interests? Or it may be a court approached on the issue.
Well, it may be that the NDPP doesn't have to go to court, which is our argument. He has that power.
No, but we're not talking about the NDPP going to court. But if a court has to decide these issues, as I understand the English authorities and the dicta that were referred to, whether it's Latip or any one of the others, that what they say is whether or not that conduct should be considered as one that calls an end to the prosecution, what has to be weighed up is the conduct as against the public interest considerations, and that is within the discretion of a court.
Yeah.
That's correct, isn't it?
That is correct.
Well, in this case, what you're ultimately putting to us, as my two brothers have put to you, is that notwithstanding that the merits are good, notwithstanding that Mr. Mshe himself says the prosecution itself wasn't tainted, as in there was no fiddling with the evidence, there was no investigation that was achieved by coercive, or information that was achieved by coercive methods. All you're left with, and that is debatable on the papers about the timing and who was responsible for the timing. But let's assume for the moment that Mr. McCarthy wanted to have a particular timing. How does that make the prosecution a bad one?
So, if I may respond this way, Justice Nafsa. So we know what the conduct was. We know what McCarthy was doing. He was trying to delay it, and we must accept that he was trying to delay it because there was concern that if the indictment was served before Polokwane, it may boomerang in the sense that people may rally around Zuma and President Mbeki would not get re-elected. So that is the conduct. Now, the court said
Mr. Epstein, Mr. Epstein,
in the judgment.
Before you proceed, can you fact check this in your response? When did Mr. Mshe finalize the authorization of the poker and of the institution of poker proceedings? Didn't he finalize it around December?
Well, the decision to prosecute was taken, I think, 29 November, but I'm a little off guard. I don't know the date of the poker.
But when did he sign?
Was it the 12th of December, 11th or 12th of December?
Yes.
Yes, I think that my memory serves. I think you
Well,
jogged my
perhaps
memory.
you Junior can look at the chronology.
Yes. So the court said, in our view, this is in the judgment at paragraph 52 of the court I quote, in our view, the alleged conduct of Mr. McCarthy, as appears from the transcript of the recorded conversations, if proven, constitutes a serious breach of the law and prosecutorial policy. It is not even necessary to refer to his role in the Browse-Moll report, for which it seems he was not admonished. His conduct, as alleged in the transcript, again, if proven, certainly calls for intervention. This will involve an inquiry into the allegations, and if need be, also censure by court of law. So the court found that this conduct was a serious manipulation. It constituted a serious breach of the law, and the DA believed also it was conduct. They say
manipulation of what, Mr. Epstein? What is the manipulation?
So, Justin, if I could just get there, if I could just have a moment. So, the court criticizes the conduct. They say, if proven, we submitted. It was the NDPP's discretion to take into account what he had. He didn't have to go to court to prove it. Notwithstanding, the court said that it should have been taken to court. So what do we have? What is the essence? What did he do? McCarthy was in a position to have the indictment served. Downer wants to proceed. Downer wants to proceed
but
because...
when was it finalized? When was the indictment itself finalized?
Justice Chiki, the decision was taken 29 November to prosecute. I think Poker was round about 12 December, and the indictment was served, I think, just after Polokwane, 27, 28. Poker was signed 14 December 07, just before Polokwane.
Just before Polokwane.
Yes.
But its actual finalized, when was it ready for it to be served on Mr. Zuma? Because my sense of the papers is that if we put aside the debate on when it should have been served, whether it should have been served before Polokwane or after Polokwane, the point, well, my sense of the papers is that it was in any event ready only after Polokwane.
I think, Justice Chiki, the certificate, the indictment can be served without a certificate. The Poker certificate only has to be available at trial, provided the party hasn't pleaded. So whether they were waiting for the Poker certificate, I'm not sure, but they certainly, Mr. Downer was very upset when he was told that it would be postponed, and he made a lot of noise about that. He made it clear that he didn't want it postponed, and this was the egregious conduct.
What has been put to you by my colleague is the following, that objectively on the facts, because there was a few things had to be done before Polokwane, that whether or not there was manipulation was overtaken by events, because the indictment was only ready for service on or about the 14th of December. Nobody was going to, over a long weekend, start serving indictments. So whether or not there was manipulation, in fact, the indictment could only be served after Polokwane, which means that to the extent that there was manipulation, it is in any event irrelevant because it had no bearing on the ultimate timing. That's as I understand
Justice Kachai, I think with respect, we see from the transcripts that Bulelani Ngcuka was saying to McCarthy, whatever you do, don't serve this weekend, just before Polokwane. So on that basis, McCarthy must have known the indictment was ready to be served. But I haven't finished my submission as to why this was an abuse of such a nature that it was not in the interest of the public interest to continue.
But what's being put to you is whether in fact it was an abuse, and whether it had an effect. If you have regard to the fact, let's just recount the facts. Minister Mabandla herself was concerned about the timing, was she not?
But for a completely different reason to that of McCarthy.
No, but be that as it may, even if you bring in Mr. Casseroles at one stage, and what you make of him is a different question. But he too had similar concerns about what the effect might be. What the effect of serving before Polokwane in the light of heated political emotions.
But they were concerned that the effect might be that there would be problems within the country, as opposed to McCarthy's concern, which was that President Mbeki would not be re-elected. So he was was prepared to delay the indictment for a valid reason, but it turns out that he was persuaded, whereas for the wrong reason. And McCarthy had his own agenda. And when he found that out with the tape recordings, when he found that out, and then he took into account McCarthy's history with Browse Mole, he realized what he was doing and what he was up to.
Okay. Could I just understand that as far as you're concerned, whatever the objective factors might be, whatever Minister Mabandla's concerns might have been, whatever anybody else might have thought who had legitimate cause to think that timing was a problem because who knows what might happen in respect of instability, because that I think was the legitimate concern, was that not?
That
national instability.
Well, that was Minister Mabandla's concern,
that was
and that was why Peshe was prepared to postpone.
But if you add what my sister Chiki put to you, to the question of they'd already had Justice Msimang being angry at proceeding without all the formalities being in place in the past. So in terms of whether the racketeering charges and the certificate was obtained properly, it was probably imperative to ensure that it was all in place before the indictment got served. Are we?
Yes.
Yeah. Well, if that is so, then how is the prosecutorial process? And that's the difficulty I have, that it's the prosecution itself. When you serve the indictment or how you serve it, how does that impinge on a case? And maybe in respect of Latif and all of those cases, and if you look at pages 130 to 131 of Mr. Mshe's, he doesn't seem to do that weighing up process. He doesn't say to himself, well, hang on, how much of this, if we're talking rationality, how much of this, having discounted the three other factors, which is fair trial rights, having discounted the question of how you mount the defense, he says none of those impinge. He says, but it offends against one's sense of justice. Following the Latif and the other cases in the UK, the public interest ought to have been weighed up as well. Is that not correct?
Well, but that is what he said he did. He said, I accept the merits were good. I accept he would still get a fair trial. But in terms of Maxwell, there are two categories where you can stay a prosecution. The one is where you don't get a fair trial, and the other way is where you have an abuse of this type, and you can stay the prosecution because the court won't countenance any kind of abuse that reflects not only on the integrity of the criminal justice system, but also on the integrity of the court.
Could we go to page 117 of Maxwell, where there's a reference to Latif?
Yes, is this
it's in the bundle of documents. It's in the bundle of cases and articles.
We deal with it in our heads, just as that paragraph 69 of Maxwell. Just find Maxwell.
Well, let's read it because it's important in this weighing up process, and the concerns raised by my brothers Leach and Kachalia, as well as by my sister Chiki, all come into it. The law is settled, says what Lord Steyn said in Latif. Weighing countervailing considerations of policy and justice, it is for the judge, in the exercise of his discretion, to decide whether there has been an abuse of process, which amounts to an affront to the public conscience and requires the criminal proceedings to be stayed. But what's important is the latter part of that quote. But it is possible to say, that's really at the end of that quote, that in a case such as the present, the judge must weigh in the balance the public interest in ensuring that those that are charged with grave crimes should be tried, and the competing public interest in not conveying the impression that the court will adopt the approach that the end justifies the means. So we must agree that that's what goes into the pot.
Yes, and in Mshe's statement he plagiarized this, what he said from here.
Yes, accepting that I'm not sure he followed it to the letter, because he doesn't, where does he deal with the graveness of the offence in relation to the other public interest? Does he do that in the statement, Mr.
Well, he does. He hasn't summarized his entire analysis, but he said, I took it into account.
But let me tell you about this plagiarism to which you refer, because that too goes to his state of mind. Here you have a director of prosecutions who plagiarizes some other judgment. All right? That judgment refers to an abuse of process. Abuse of process, as we know in our law and as we know in foreign jurisdictions, an abuse of process refers to an abuse of the court process. On appeal, that very judgment that he plagiarized makes that clear. It sets the judgment aside which he relies on. That is not disclosed to the court. So what he does is which may well warrant a prosecutor deciding that because of this abuse of power, I am going to stop the prosecution. I can accept that. But what he does is he invokes the wrong doctrine. The doctrine abuse of process deals with permanent stays. What I'm putting to you, therefore, is this. That is another indication of a man operating with at least no idea of what he's doing, or alternatively, not applying his mind at all to what he's doing. But with great respect, those reasons are nonsense.
Justice Kachale, he referred to...
Back, if you don't want to answer the question, you don't have to answer it. But I need some clarity on this. What I'm saying is those judgments refer to an abuse of process doctrine, abuse of a court process. It's a different situation. He cannot invoke a process unless he says, I'm invoking this as a comparison between what I'm about to do and the way the courts have approached in foreign jurisdictions the abuse of process in permanent stays. Then I can understand what he's doing, but that's not what he's doing. So that's what I'm putting to you, that he's barking up absolutely the wrong tree.
And I certainly will answer it, Justice Kachale.
Yes.
I won't avoid the question. I referred to Maxwell, and I want to first quote from what Maxwell says. It is well established that the court has the power to stay proceedings in two categories of case, namely, one where it is impossible to give the accused a fair trial. I said that's not the case here. Two, where it offends the court's sense of justice and propriety to be asked to try the accused in the particular circumstances of the case. In the first category of case, if the court concludes that an accused cannot receive a fair trial, it will stay the proceedings without more. No question of the balancing of competing interests arises. In the second category of case...
Can we stop there? We're not in that category.
We're not in that category.
Okay.
In the second category of case, the court is concerned to protect the integrity of the criminal justice system. So if I can just have a moment to again say what happened. Downer was very concerned about not serving the indictment. The matter had already been struck off the roll by Msimangche. He was concerned about a permanent stay application. He didn't want this to happen again. And he in fact wasn't being told the truth, Downer, about what was happening. He was intent that the indictment should be served. And you've got the head prosecutor who is holding back with the indictment because Polokwane's come up and he's not running the prosecutorial process as he should with anybody else. He's keeping it in abeyance for one reason only, and that is to satisfy his own personal interest that his champion, President Mbeki, should remain the president of the ANC and become the president of remain the president of the country. Now that is the conduct. Can I add to that, Justice Kachale? If one accepts that is the conduct, which with respect must be the case, if that conduct is serious, if it's egregious, as the DA themselves thought, as the court felt, then what it comes down to, it comes to rationality. And Justice Kachale, in a recent decision which you gave in the Free State University matter and AfriForum, you said, when you look at the facts, once there is conduct, it falls within the discretion of the decision maker to decide how serious that conduct is. It's his, and how much weight to be given to that conduct. And it's not for me and it's not for the court. The court might well have done something different. The court might well think it's unreasonable, but the cases are replete with statements to the effect, whether it's Batterstar, pharmaceuticals. The fact is this court cannot look at it as what this court would have done. Lots of people here might have taken a different view, but it's not for us to second guess that. If this power is given to him in terms of the Constitution, he exercised that discretion. One doesn't like it. Can I just make? I want to try and make the point and I think I can make with this last reference. Corner House. The Corner House case which we refer to, there you had a situation where the investigating director in England was investigating possible corruption between the Saudi Arabians and an arms supplier. And what happened there is the Saudi Arabians, it was extortion. They said, if you carry on this investigation, if you carry on looking at accounts in Switzerland, we won't buy Typhoons from you, we won't cooperate with security, and we won't buy further arms from you. And he succumbs to that extortion. And the House of Lords says, as long as he's in good faith, it's his discretion. And lots of people were very, very unhappy about that, understandably so.
Are you suggesting that we would follow the same route if a similar set of, that our constitutional court would follow the same route?
No, I'm not. What I'm saying, what the constitutional court will say is, as unfortunate as it is, we cannot impede upon the discretion given to a decision maker in these
Could we
circumstances.
just wrap up the principles in relation to Maxwell, and it's in relation to what you read. You read from paragraph 13, you read about the two categories. And really, as my brother pointed out, this was in relation to an application for a permanent stay of proceedings, or at least in relation to a permanent stay of proceedings. Can we accept that that's the context in which it was?
Yes.
A number of those cases deal with police conduct, prosecutorial conduct in relation to witnesses and the like. It's manipulating the evidence and the process in relation to the prosecution, because it's under the heading prosecutorial misconduct. So far, so good.
Yes.
In relation to the second category, which is where we're not talking about fair trial rights, but we're talking about, and this is what it says at the end of 113, no question of the balancing of competing interests arises, but in the second category it does. The court is concerned to protect the integrity of the criminal justice system. That's what the second category is about. And then there's that last part in Latif, which is, but it is possible to say, and that's where the weighing up gets done. And the weighing up that gets done is not only that the public interest ensuring that those are charged with grave crimes. That's the second part that has to be weighed. That's not done by Mr. Mshe in his statement, Mr. I think you have to concede.
I do concede it. In fact, he concedes it because he says the merits don't come into play, or the merits are good. The prosecutors think the merits are good, so he must have taken it into account. He must have weighed it up. He says the merits are good.
He doesn't say I've done that weighing, and in doing the weighing, I come down on side X rather than side Y. Where does he say that? Because that's what Maxim says you've got to do.
Where's the statement? Where's the statement? I might highlight it. So if I can just have a moment just to find the share statement, which I've got here, that I've highlighted.
It's at page 130, 131 of volume 1. So if you take the main bundle, you get it at page 130, 131.
So, as you read out earlier, Justice Nafsa, he said the representation submitted by the legal representative pertain to the following issues, and the first one is the merits. And then he says, I need not say up front, we could not find anything with regard to the first three grounds. So we accept, he knows the merits are good. In fact, he ends off by saying that, by recording that the prosecutors, he says, let me also state for the record that the prosecution team itself had recommended that the prosecution should continue, even if the allegations are true.
Well, can I tell you what is fatal to the argument you're making now? Just look at page 130. Let's go through it very carefully, because we've got to debate it conceptually in relation to the Maxim test, which I think you have to accept is the test. You propound it as the test. McCarthy, it's line 34 of page 130. Are you there? Look at page 130. It's
Is it after background, Justice? 1102. Which is going to be yours?
Could you just read it very carefully, where it says Mr. McCarthy used the legal process?
Yes.
It says Mr. McCarthy used the legal process for a purpose other than which the purpose was designed to serve. That is, for collateral and illicit purposes. Let's just accept that for the purposes of the argument. It does not matter. So he says it does not matter that the team acted properly, honestly, fairly, and justly throughout. Mr. McCarthy's conduct amounts to a serious abuse of process and offends one's sense of justice. Well, as Maxim tells us, it does matter. It does matter because it's the gravity of the offense and the process itself. What Mr. McCarthy did was not simply being over-diligent, it was pure abuse of process. Well, we know abuse of process has to be weighed up. That's what Maxim tells us. Go to the next page. If Mr. McCarthy's conduct offends one's sense of justice, it would be unfair as well as unjust to continue with the prosecution. He doesn't say, I've weighed the public interest in relation to the gravamen of the charges and in relation to the fact that it has to be weighed up. He says, I'm just putting one thing on the scale, and that's my conclusion.
Yes.
Well, am I wrong in that, Mr.
Well, Justice Nafsa, I think, with respect, that when he says, I concede the merits are good, the prosecutors want to carry on, he has taken into account there are strong merits in this case. And when he looks at the abuse of process, and he says, but the abuse is so egregious, and I'm going to make a finding to stay, it must mean that he says, notwithstanding good merits.
No, this is what Maxim tells us. This is what Lord Steyn tells us to do. Must weigh in the balance, the public interest in ensuring that those that are charged with grave crimes should be tried. That's the one part. The other one is competing public interest in not conveying the impression that the court will adopt the approach that the end justifies the means. All he does is he takes the second into account. Where does he ever say, I've had regard to the public interest that those charged with grave crimes should be tried? Where does he say that? Where at all in that statement? That might bring us to another point. We've got here Mr. Mshe is the central figure in all of this, isn't he?
Yes.
I mean, he's the central figure. Why is there no statement by me? Why is there no affidavit by Mr. Mshe other than a confirmatory? Shouldn't we be expecting that the central figure in this entire drama should be telling us what motivated him, what he considered, and that whole question about what he said to Downer, whether he, according to Mr. Hofmeyer, he told Mr. Downer one thing, but it wasn't the truth. It was an untruth. Why don't we have Mr. Mshe on affidavit telling us what he did, what he considered, how he dealt with Mr. Downer, and how he dealt with all of these others?
Just now, so there's a supplement. There is a supplementary confirmatory by him.
Yes, that's.
I think there's two affidavits.
Well,
there's that one, and then
take
there's
take us to it.
Got it in core bundle at volume 4, page 619. May I say while I'm looking for it, Justice Nafsa, that whilst there are conflicts in the affidavits, I had no hand in drafting them. Just want to mention that for the record.
Sorry?
I just want to mention that for the record.
We won't direct that accusation at you.
I think it's wise that you seek that shelter. In certain respects, this affidavit from Mr. Hofmeyer is scandalous.
Well, it is.
Unsubstantiated allegations, political statements of fact, unsubstantiated by the facts. If anybody has to be condemned, it's Mr. Hofmeyer.
And hence I wanted to place on record mine.
Well,
lack
perhaps
of
you should tell us why you're distancing yourself from the affidavit, because there must be something in the affidavit you're referring to us, referring us to now, that where the shoe will pinch. Now, what is it?
No. Oh, that's coming now?
Yeah.
Oh, no.
I
don't think it gets worse. But let me just find that supplementary.
No, but you'll find, why are you looking for the affidavit? What my colleague presiding is putting to you is this. You see, what is involved here is a process of rational decision-making on the part of the National Director of Public Prosecutions. What happens here is that Mr. Hofmeyer puts up this lengthy, convoluted affidavit, in many cases makes allegations, draws inferences, makes allegations that are unsubstantiated. Mr. Mshe, we're trying to investigate Mr. Mshe's state of mind. He merely puts up a confirmatory affidavit on the critical aspects and says, yes, now everything that Mr. Nuka says, that Mr. Hofmeyer says, including the fact that I was being manipulated by McCarthy. I confirm all of that. That's what he does. In 3 lines, he confirms it. And so what is being put to you is that when it is Mr. Mshe's state of mind that is being investigated and the reasons he gave, surely one expects the principal answering affidavit to be made by him, not a supplementary affidavit where he then seeks to clarify matters where he missed out on the first bite of the cherry. That's what's being put to you.
No, with respect, I wouldn't take issue with that.
Well, could I put something else?
But the affidavit, there is a...
I have found the affidavit.
Yeah.
I'll tell you where it pinches, really pinches, Mr. Actually, page 630. So it's before that. he, at some stage, sorry, I picked it up a minute ago and I've now lost
Probably
it.
52.
But no, he
Paragraph
says, he does deal with Downer, persuading us necessary therefore to support the decision. He does talk about the decision to, he says at some stage, I'm sorry, I missed it now, but it is...
The corporate decision is...
No, it wasn't a corporate decision. He said it was the DSO's decision. It wasn't mine.
41, Pat, we were particularly uncomfortable that in several affidavits in the past, decision had been described as that of the NDPP without any qualification.
Yeah, and then he says quite emphatically at some stage, and this takes us back to the first point. He says, well, that decision was made by the DSO. It was all up to McCarthy. And that gives you difficulty on the first point we debated, doesn't it?
That does, that is, and I refer to him having said that it was mischaracterized in paragraph 52.
Well, exactly,
That's,
exactly.
perhaps that is putting it...
yeah, I mean, that almost completely, doesn't that just stultify your attempt to distinguish? That, I'm afraid, is a yes or no answer, Mr. Webster.
Well, Justice Nafsa, it cannot be that he says that it's unfortunate that it was previously characterized in a particular way. I've raised that. He cannot say that. The fact of this, we're back to the first point, is that he made a decision. He used the wrong section. The only question is whether he could have used another section.
No, but my brother Kachalia pointed out to you, nobody seems to know who made the decision. I mean, one person says it was so-and-so, then they say perhaps it was a corporate decision, perhaps it was, then somebody says, but it was a DSO.
But when we put in these additional heads, I proceeded on the basis, the one basis that everyone is bound by, and that is the SCA's decision in 2009 that it was Mshe's decision. And you can say that it's a corporate decision. The fact is that that was what was advanced to the SCA by the NPA in 2009, that it was Mshe's decision, and that's what the court found.
Yeah.
There's only one aspect that I've got
sorry, I
left.
think it is much earlier than that. You may want to consider it. It may be an appropriate time to take the adjournment. But it is page 624, at the end of it, there's a discussion about Downer's involvement. And then 625, para 30. He does talk about the collaborative approach, but he does say he made the decision independently, McCarthy, 28. McCarthy decided to institute the prosecution. McCarthy told Downer to finalize them. He knew that he had the power to do so, and he did. I mean, how do you get by it on your own affidavits? Mr. Epstein, perhaps you can take the tea adjournment to consider it, and we'll see where we go.
He says earlier on page 627, in accordance with all the above, the investigating director, director of special operations, in consultation with the head DSO, me and other deputy acting, and the prosecuting investigating team, has decided to institute prosecution.
Yes, well, is it a convenient time?
Thank you.
We'll take it.
To reconsider leaving the article. I can't just concede to the case like that.
in defense. He did not consult me. He made the decision. He knew that he had the power to do so, and he did. So he's.
I would like to take instructions from the
Yes,
principal.
well, I think you should.
I'd also like to hear what Mr. Kemp has to say. Maybe he's got an answer that I don't know of.
Yes, but I mean, you're independent counsel. What Mr.
I am, but maybe I haven't thought of a legal argument, and that's what
All right.
matters. Maybe
Okay.
there is a legal argument.
All right, my brother Leach has a question for you.
Mr. Epstein, I'm concerned about one thing. Your entire case is that McCarthy's actions in delaying until after Polokwane, the actual service of the summons, of the indictment, had as its motivation the advantaging of Mr. Mbeki's chances rather than those of Mr. Zuma. In a nutshell, and that allegation is made repetitively by Mr. Hofmeyr in his affidavit, on what facts do you rely to support that conclusion?
It's purely the recordings which are mentioned in Mshe's statement. You would have seen that there's a transcript of what is said and then there's a comment.
Could you take us to the specific parts of the transcripts and so we can look at those and see if the conclusions are justified? What volume are you in? It's one of the supplementary volumes, is it not?
I'm in the core bundle, volume 6, at page 1092. Is it in? It's also in the main bundle, I think, in volume 1.
Yes. All right, so what you're in core bundle volume 6, what page?
1092 is the start of Mshe's statement.
That's the statement.
That's the statement, because when he attaches the recordings,
Yeah.
the recordings are attached in my papers at 1097.
Well, which particular recordings, and let's see what meaning you ascribe to them.
So under allegations of abuse of process and recording of telephone calls, it says calls about manipulating the timing of charges for other purposes. LM, which is Leonard McCarthy. The second thing is, I remember what you said, and I was talking to Bulelani and Nuka. I remember what you said on Saturday. I read yesterday's Business Day editorial. You must read it. Nuka, just remind me, McCarthy, yes, it's in line with your thinking. And then the comment is the
Sorry,
editorial.
could I just ask you that the Business Day editorial seemed to have been that it serves Zuma's purpose not to institute before Polokwane. Is that correct?
Well, I can only look at the comment of that. The editorial is of the view that it appears to benefit Mr. Mbeki, where Mr. Zuma is not facing charges.
Well, I mean,
And he said it's in line with your thinking.
isn't that debatable in a sense? It's debatable. I mean, if he'd been charged before Polokwane, who knows whether his charges would have been better or not? I mean,
It is. So they draw inferences, and one looks at a conspectus of all of what follows.
okay. So it's the first one. Which
So
other?
that's the first one. The second one is, the third issue is I met with the guy I mentioned, and you know his line is almost like that of Sam. There's laughter, but he said he says he will speak to the man, but he is back over the weekend, but he feels very strongly that I should not see the guy directly. The comment is there is reference to the need to meet or discuss with the man, the other guy fellow. It is clear that it is the president, that's Mbeki. In most cases, it is not clear who is meant.
Well, do we know that for sure? I mean,
None of this is for
let's assume for the moment that Mr. McCarthy is a Mbeki supporter. But how do we get to this
Well, let's go
conclusion?
to number 6. So,
Yes.
number 6, so you the only one who can just save the country from this madness. And then further down, and what does the big man say? Is he all right? I don't know. I want to still try to call him later tonight. He's in a meeting the whole day at Shell House of places. I did what you said I should do. You did the right thing. Then McCarthy, up until Friday, I received a strong memorandum to say charge now. Nuka says Friday. McCarthy says no, this Friday. The team says that we have been messing around with this thing. We are allowing ulterior considerations to come in. It will become an impossibility later. We now must take action and deal with finish and clause, Jackie Salibi said. But we will talk when I see you.
Well, could we stop at that one? That is, they're dealing with Downer and the prosecutors on the ground being intent that this thing must be pushed along.
Yes.
And so that says, they say we've been messing around with this thing, we're allowing ulterior considerations. So they're concerned about what the team is thinking. So
now, the next one, I think, follows from that. McCarthy said, but listen, I think you guys must keep your heads open about when factor. Because, I mean, we will file our docs tomorrow, and Mshe's going on leave tomorrow, and I'm acting. And the comment is the when factor.
Sorry, isn't that neutral? You must keep your heads open about the when factor.
Well, the when factor.
Why is that prescriptive, rather than it being keeping an open mind?
So the comment is the when factor is an apparent reference to whether Mr. Zuma should be charged before or after Polokwane.
But who makes that comment?
That's made by McCarthy. I think you must keep your heads open about
the when factor. The comment in the margin.
Oh, who makes those comments?
Is it the NIA?
No, I don't think that's the NIA. It must be.
Whose comments are?
I imagine I think it's the NPA, but I imagine it's some Share's comments, Hoffmeyer's comments.
Well, do we know for sure?
No, aren't those the references? Sorry, is that not the references? Did the DA not explain those in there? Well, I don't know.
No. Well, tell us. I mean, I'd like to know. Were these the representations that were made by Mr. Zuma's team, or were these instilled in the margin by the NIA?
I will see if there's reference to it. I don't see reference.
So what do we do with those in the margin? I mean, that's the view of somebody.
He says at the beginning, I will now deal with the contents of some of the recordings as set out below. I believe that is in the public interest to make this available, as this matter is of huge public interest, and I believe that it's important for members of the public to be able to draw their own conclusions.
You are now reading at number what?
Conduct. I was reading this to 20. I wanted to see if he indicated there whose comments these are.
But I mean, can we take them into account at all? We don't even know who made these comments.
But there are comments that Share clearly has relied upon, whether they were his own comments or whether they were comments of others given to him about what this meant. He's relied on these comments and the inferences drawn from them.
Okay. But I mean, as I put to you, if you look at the one date Wednesday the 12th, where McCarthy is speaking, far from that being prescriptive or manipulative, it seems to say we'll keep our options open.
Well, the next one, the following at the bottom of that page, as long as you don't do it this weekend, McCarthy, if we hold it back, it will be because the clever people like you and others are saying to us that the country needs cool heads. But I would hate to have be seen to be wrong later.
But why is that too? Why is that particularly nefarious or to be decried? I mean, this is saying, as I understood it, if you take into account what Minister Mabandla herself thought and Minister Castles at the time, that you just got to keep a cool head. Let this not lead to instability. Why is that in itself?
But he's saying just don't do it this weekend.
No, but hold on a second. let's come back to that. It's not Bulelani Ngcuka who we are directly concerned with here, even though what Mr. Hoffmeyer quite unflatteringly refers to that Bulelani Ngcuka was, for practical purposes, Mr. McCarthy's handler. But let's leave that for a moment. He says, as long as you don't do it this weekend, Mr. Ngcuka seems to be pushing. Leonard McCarthy, on the other hand, seems more reticent. So he says, firstly, keep an open mind. Second, he says, well, if we don't do it by this weekend, it would have been because several people, including you yourself, Mr. Ngcuka, the clever people, would have prevailed. But Leonard McCarthy does not seem to be sort of driving or pushing this by any means. Am I wrong in that?
Well,
doesn't the top of the next page support my brother Kachalia? Just look at the top of it.
McCarthy says it might change. Ngcuka says, I can't keep an open mind. You can't do it this weekend. Our minds won't change. And then he says, just don't do it this weekend. And McCarthy then capitulates. And he says, I won't move this weekend. If this changes, just let us know. And Ngcuka says, it won't change. But this also has to be seen in the entire context of this. It follows McCarthy says, I will get, this is now, the date is the 13th of December, just before Polokwane. And he says, I will rather come myself. I want to drop off a parcel, but he wants to hand it to him personally.
But the comment in the margin, and I don't know whether it's right or not, that's the difficulty with these comments. It was to deliver a draft of the Concord Papers.
But the inference they drew was when he said, Zuma will say we're conspiring against him, McCarthy says, can I ask, the script has not yet changed, it's not changed yet. And the script they say is, the position of the script is apparent references to whether Zuma should be charged before or after Polokwane. I can't tell you, Justice Namsa, whose inferences these were.
No, but look at
what he relied on.
Look at the last comment by McCarthy before Friday the 14th, because I feel like going to Polokwane and charging him there. So far from wanting to put it off, Mr. McCarthy is saying, much like the Downer and company was saying, let's go and charge him.
But he listens to Nuka. That's the problem. He listens to him.
But he also listens to Minister Mabandla.
And where from these references and these transcripts, where's the quantum leap between what gives rise to the quantum leap between the delay of the prosecution, or when to charge, and the advantage, the perceived advantage of the then presiding president, Mr. Mbeki?
So again, in context, when Mshe listens to all of this, what does he know? He doesn't only know what he reads or hears. He knows that he bumped into McCarthy at the airport, and McCarthy makes comments to him that Hofmeyr is not being loyal to Mbeki, and they have a heated exchange about that. So he now knows that McCarthy, and he says to McCarthy, it's not right for you as a prosecutor to raise this. You shouldn't get involved in these matters at all. And they have a heated exchange. Then, of course, he sees that in the context of the Browse-Moll report. Now the Browse-Moll report has been leaked. He knows about it. He knows that McCarthy was instrumental and behind what Mr. Trump calls fake news and the information peddling.
I'm not sure.
And so in the light of that, he knows what he was doing in the Browse-Moll report. He's tried to leak information to discredit
could I ask you to turn to the page 1101 in the core bundle? Right at the top, under date 16th of the 12th. Do you have it? Where Leonard McCarthy's initials.
I've got that.
Do you have it?
Yes.
I have been advised, he says, this is not McCarthy driving anything, to give Obut and Oyan a break in the interest of South Africa. 10 US times, I suppose the QV is Quo Vadis. So again, he's not saying it's my agenda or I want to do this. He's saying I've been told. And the reality is that Minister Mabandla did tell him, you can't do this now. So what my brother Leach is putting to you is, if this is all the material you rely on, then it's conjecture and speculation and assumption.
Yes, it was conjecture, but based not on just what he heard here, but as I say, based on the conduct of McCarthy in the Browse-Moll report and what he tried to achieve there.
But it coincided with his own view, which, having spoken to Minister Mabandla, he'd come to the view that it would be inappropriate to serve the indictment before Polokwane. That's why when he had a discussion with Mr. Downer, and Mr. Downer got upset, angry, correctly so, he then backed off and said, well, I assure you that this is not going to be Minister Mabandla's decision, it is my decision. The fact of the matter is he had come to that conclusion independently of what McCarthy's view was.
Justice Kachalia, the question then is, to what extent can a court draw inferences different from those which the decision maker drew with the information they had before him and the background information that he had?
That goes to rationality, because if the conclusions he drew are in fact not supported, by hard fact or objectively verifiable fact, well, how do you get to rationality?
Well, it will go to rationality. The director sits with a power. The power is to continue or discontinue prosecution. The purpose is to make sure that whatever he does, that the integrity of the criminal justice system is not impugned, and based on that, he makes that decision. Now, what is happening here is a court and the court quo second guessed that and said, well, if we were sitting where you were, we wouldn't have made that decision, and therefore it's irrational.
Well, I'm not sure that it's quite as simple as that. It may not be quite as elegant as one would wish, but it seems to me that they took into account all of the things he should have considered.
Because McCarthy's conduct, I mean, the Joint Standing Committee and investigations, they found that his conduct in the Browse-Moll report was so reprehensible, and Pecolia told him to stop it, and he kept peddling this fake information, which was clearly to aid President Mbeki. And then you get to these telephone calls, you put two and two together, and he draws that conclusion.
What is the Browse-Moll? The Browse-Moll report is completely unconnected to the prosecution in this case. He was an Mbeki supporter. This was a political campaign that he might have been in. That's the reprehensible part. But how did it impact on the prosecution?
Well, only because of what McCarthy's object was in the Browse-Moll fake news peddling, coupled with the fact that he then delays the prosecution when Dana says don't do it. And he's having these discussions with Nuka, who definitely doesn't want him to.
But my brother Leach asked you, where did he delay the prosecution? And we've now gone through the transcript of those recordings.
Not the indictment. He delayed the indictment. He made the decision.
Well,
the service of the indictment.
Where did he delay? Where can we say this delay was motivated in order to somehow undo the prosecution, or in fact to accelerate the prosecution? I mean, I'm not quite sure that I understand where it's all at.
Well, it was to make sure that if they proceed with the prosecution, it would not impact on the Polokwane conference. And they've got a prosecutorial process in progress, and they decide that they are going to hold back on it because it will influence the outcome of an election.
All right. All right. Shall we go to, if you're done with that part, can we go on to the next part where it's really territory, what's within the court's remit and what isn't?
The part where the court said he must face the charges in the indictment.
Yes.
We deal with that in our heads of argument. At page 55, paragraph 55. Now the point is this. In the, what I call the Harams DP decision, where they dealt with motion proceedings and then dealt with what Nicholson J. did in the matter before him, and where he dealt with matters which were not in fact issues in the court, where he dealt with political meddling, and the SCA said that it wasn't his role or his place to deal with any of the political meddling. Judges are part of the general citizenry, and judges must deal only with what is before them.
Well,
now in this case, what was before the court quo was simply an application to set aside the decision and an order for costs. They did not ask that the court make a decision about what should happen to the charges.
Could I understand this? Mr. Abrams' concern seems to be that we, the prosecutors, we decide. It's not for courts to decide. That seems to me to be the driving force. Is that correct?
On this issue?
Yes.
Yes, that is so.
All right. Now, let me ask you this, and you're right. I mean, we accept, I think all of us on this panel accept, that it's our job to see whether somebody else has overstepped the mark. It's not our job ourselves to overstep the mark. That seems to me to be correct. But what is the effect of a prosecution, a decision on a prosecution that remains extant if the decision to undo it is set aside? I mean, as a matter of law and logic, what happens? It remains extant, doesn't it?
So there are two issues which arise. The first is, and really this court may feel that it's not within its ambit to give any direction on this, but the NDPP, Mr. Abrams, would like to know if this decision is set aside, what does he do? Does he face the charges, or is it for him to make a new decision? Now, the problem is this. When the decision is set aside, you just put me, Justice.
I don't understand the difficulty.
But if I can just have a moment, please, Justice Richards. When the decision is set aside, the question is, which has just been put to me as I understand it, doesn't it revive the previous decision? The problem is that Justice...
Sorry, not revive. The effect of the decision not to continue with the prosecution is set aside. What remains is a decision already made. It's a matter of law and logic that must be so.
So we draw the parallel with what happened before Msimangje. There, Mr. Zuma was facing prosecution. He came to court, the prosecutors weren't ready. The NPA was not ready. Msimangje says, call your first witness. They say we can't, and he strikes the matter off the roll. And then Mr. Zuma is taken to court, and the charges against, when he's in court, and the charges against him were then withdrawn. And the Constitutional Court in the Tint matter and in the SCA matter said what went before Msimang was spent, and a new decision had to be taken.
But that's correct, but that's because the jurisprudence is quite clear. When a matter is struck off the roll, that terminates the prosecution. We're dealing with something different here. What you have here is a decision to prosecute made by Mr. Mshe, a decision which thus far has been unchallenged, legally, technically. You get to the point, that's point X. Now it gets to point Y where he says, I want to undo that decision. You say your undoing is invalid. All that remains as a matter of law and logic is the decision to prosecute, which has as yet not been set aside.
Justice Nafsa, I hear that, but there's a parallel with what happened in this matter, because after Mshe withdrew the charges, Mr. Zuma then went back into court, and the judge, the magistrate, said, the charges are withdrawn, you're free to go, I imagine, words to that effect. So he goes, so the case is over. And there's no difference between it being struck off and saying the charges are now withdrawn, Mr. or this.
But it's almost a plus petitio, Mr. Epstein. If the legal effect of the striking of the roll, and we know what the jurisprudence is in relation to that, if the legal effect of that is that the prosecution is terminated, as in it's dead, you need a decision to revive it. This is very different, and I want to know why you say it's not different. You have a decision to prosecute, point X. You move beyond that, and that's up until now unchallenged. It's extant. Up until point Y. Point Y now is the attempt to undo it. If the attempt to undo it is invalid, then what do you have left as a matter of law, logic, and practical reality? And I want to know why it's not different.
Well, if I can take you in our heads to the decision of Branche and freedom under law, there he was dealing with 6A of the NPA Act, where somebody has not pleaded. Mr. Zuma had not yet pleaded. So the question is, Branche says, as I see it, the withdrawal of a charge in terms of Section 6A is final. The prosecution can only be recommenced by a different original decision to reinstitute the proceedings, and unless and until it is revived in this way, the charge remains withdrawn. But there is another portion, I have to hasten to say, in the same judgment, which I have difficulty reconciling, where Justice Brunt said that as soon as the charges were withdrawn, this was in the Luli matter, they were automatically reinstated. As soon as the decision was set aside, they were automatically reinstated. No. I think that's what you're putting to me, Justice Nafsa. But
I'm not sure that I'm putting to you what Justice Brunt, and I think I was on that panel, was I not? But be that as it may, what I think he was referring to were proceedings in facie curiae, where if the charges are withdrawn in court, well, that's the end of the matter. Must be so. Yes. It's a judgment that I think was delivered last week by this court that says that, or that's the effect of it. It's withdrawn, it's the end of it. non-constat, where the contestation is here, it's a civil contestation. The contestation is about whether the decision to withdraw is correct. Once that is set aside, the decision to prosecute, which is unchallenged, not set aside, there's no withdrawal in facie curia. It's as a result of a decision by the court as to the validity of what Mr. Mshe did.
So it raises this problem. With the Nicholson J judgment, where the decision to prosecute had been, so just to put in perspective, 2007, after Polokwane, Mshe makes the decision to prosecute. That is challenged by Zuma. It comes before Nicholson. Nicholson J upholds the review, and he sets aside the decision to prosecute. But before he's taken to court and the charges are withdrawn, there's an appeal. So when the decision was made by the SCA, by Justice Holmes and Justice Kachalia, when that decision was made, he hadn't been into court. So the decision was reinstated. That's clear. In this instance, he's taken to court and the charges are withdrawn. And because 7 years, 2007, how many years? 10 years later, does the same decision still exist? That's the question, and that's what Mr. Abrams would like to know.
Technically, you are correct. They did go, and once they'd made a decision, whether if that decision is unlawful, well, it's unlawful. They then went into court, in a sense, to formalize that decision. But you know, lawyers and courts have a way sometimes of getting involved in very, very technical arguments. Let me ask you, pertinently, what is Mr. Abrams' anxiety? Because if that decision is set aside, then, as my colleague presiding puts to you, ordinarily, whatever technical hoops you're going to jump through, you will carry on with the prosecution. If Mr. Abrams' concern is that he has to apply his mind afresh to this whole case, we're going to be here 9 years later. Then there'll be another review application. And so my anxiety is somehow or the other, after 9 years, this matter, one way or the other, either there's going to be a permanent stay and this case is over, or the prosecution is going to continue. Those are the simple questions. So what is Mr. Abrams' problem?
But Justice Kachalia, I haven't heard what Mr. Kemp is going to do or say about this, and whether Mr. Kemp is going to make a state that Mr. Abrams would have to make a new decision, or whether the position is that the existing the decision set aside, never mind it's 10 years ago, still stands. So either it still stands, and then you must say to Mr. Zuma, you must now come to court, or a new decision has to be taken. I mean, there may be new, I don't know what's happened in 10 years, but that is the only issue.
What I'm concerned about is he pitches it at the level of courts are entering into terrain that they shouldn't be entering into. That's the position that you are constrained to submit. We are aware of the constraints on our power. But I don't understand why that arises for him as an anxiety, as my brother Kachalia puts to you, because if the reasoning is the charges, there was a decision to prosecute, the decision to undo the prosecution, and in a very real sense, it's almost contradictory. Your client doesn't take into account the withdrawal of the charges as being something that terminated the thing. He terminated it by virtue of a decision he made.
So it was only advanced, Justice Nafs, on the basis of the lack of clarity when one looks at the Msimang consequence and what was said in the Tint matter by Justice Holmes, that what went before once it was spent.
Just explain this to me. Am I missing something in respect of the record? Because after Msimang J strikes it from the roll, isn't there an acceptance by the prosecutorial team that they've got to start de novo?
Once it was struck from the roll,
Yes.
they would have to start de novo.
Yeah.
And it seems with a new decision.
Yeah, well, isn't that what was accepted?
Yes.
Now, where does this anxiety come from? The prosecutorial team, of which Mr. Mshe and now Mr. Abrams is the leader, the head, nominally he's bound by what happened by his predecessor unless he wants to have it set aside. So he knows that the prosecutorial team, a la Downer and the others, knew they had to start again. That's in fact what they did. That's why they put together this whole new indictment. That's why they wanted to include the racketeering charges. That's why they were intent on putting everything in place to get that indictment going. Now, if that was the position, historically and sequentially and chronologically, what's the difficulty now? Where does this anxiety suddenly come from?
It's not sudden. It's not sudden. It may not be within the domain of the court to go to deal with what the consequence is, and I shouldn't be asking the court for an opinion. But 10 years later, and it's taken a long time to get here, it would be helpful if the court could give a direction as to whether the judgment following Msimang and the judgment of Haramse are not applicable here, and that the charges are, in fact, now
No, but sorry,
the decision is reinstated.
Tell me what in the Haram's judgment or in any other judgment undoes the question of the prosecutorial decision to continue prosecuting de novo. I mean, I'm just trying to understand what it is that militates. Why is there an undoing of the decision to prosecute? What undoes it?
Can I just find the judgment and refer you to the passage which I believe does that? You got the hand?
Which judgment is this? Democratic Alliance or
No, this is the
Haram's judgment?
the Haram's judgment.
Well, that's national. It's 2009 2 SA. You should
Yes,
have.
I've got it.
What particular paragraph?
Paragraph 75.
So you just give us an opportunity to get there. Yes.
In addition, the court says, in addition, as held by the Constitutional Court, as soon as the matter had been struck from the roll by Msimang, the criminal proceedings were terminated and the proceedings were no longer pending. Removal of a matter from the roll aborts the trial proceedings. The effect of this is that what went before the shared decision was spent and a new decision to prosecute was required. The shared decision was not simply a review of the Nuka decision, which was no longer extant. On these facts, 175D, irrespective of whichever interpretation correct, no application of Mr. Zuma's reliance on it was misplaced.
I don't get it, Mr. Epstein. Maybe it's that time of day. Maybe we've been sitting too long. But I'm not quite sure where the confusion comes from.
Whether it's removed because the prosecution is not ready to proceed and it's struck from the roll, or whether it doesn't proceed because the charges are withdrawn because they've shared decision, the fact is that those proceedings are spent. And according to this, as I read it, a new decision is required. If I'm wrong, it's simply a matter of whether or not, because there's been uncertainty. And the academics who
chronologically, let's place 75 in perspective. I thought we agreed that Downer and company, as people on the ground, prosecutors on the ground, knew that a decision to prosecute de novo had to be taken. That is what Mshe did. Took a new decision. The Msimang decision had gone before it. It's what necessitated the new decision. He made that decision. He then sought to undo that decision. The undoing is invalid. Why doesn't the previous decision remain extant? I'm just struggling to grapple with this.
Because by striking the matter off the roll in the Msimang matter, just because the prosecution wasn't ready, did not mean that a new decision had to be made. They could have come back where they wanted to.
Okay,
but the court said that a new decision is required.
Can you accept this?
I'm sorry, but Jessica, if a new decision is not required, it's not a problem. But we need to. Mr. Abrams wants to know what to do.
I understand you want clarity, and And I understand technically, if one reads this, it may well be that so the proceedings are aborted. But let's just think through this practically. Practically, if the decision, Mshe's decision, is set aside, the matter's now been struck off. Ordinarily, the prosecution would continue. Now, it may well be 9 years later that the NDPP says, in the 9 years, key bits of evidence and information have disappeared. Hypothetically, let's assume that. I'm not inviting anybody to let the evidence disappear, but I'm telling you that the evidence may have disappeared. In which case, the National Director will be within his rights not to continue a prosecution, just as you can stop a prosecution midway through a trial if evidence is unavailable or whatever. So ordinarily, if we make a decision to set aside this decision, then the National Director must understand that he must continue it, unless there's some reason why he can't.
No.
And it's as simple as that.
I will accept the argument you put to me, with respect.
Okay, so in a sense, it's chicken soup, isn't it?
But now, on that basis of what's been put to me...
but it would be chicken soup, wouldn't it? I mean, he subsequently took a new decision, a new and improved set of an indictment.
We will accept that, but I don't know if the court will find it
All right, so we've done
to put it to deal with it in the judgment. The only question is then, if it really matters, is we say that the court should not have said he must face the charges.
No, but I mean, that's just sort of, if that's the logical consequence, it's not the state saying we are prosecutors and we've made the decision.
No, I think with respect to the Court of Code, it shouldn't have been said because it oversteps the boundaries of that separation of powers, and that's exactly what happened with Judge Murphy and Judge Brunt. Said it wasn't within his domain to tell the prosecution what to do. But again,
could I ask you this? If instead of in an order, we were to say in a paragraph, if we inclined against you, only in the event that we incline against you, and we found either on the technical point or on the facts, or we affirm what the court below did, what would be objectionable if in a penultimate or ultimate paragraph one were to say the decision is going to be set aside? The logical consequence of that is that the decision to prosecute made by Mr. Mshe remains extant.
Would have no difficulty with it.
Okay. All right. If we incline against you, costs?
Before you address the issue of costs, there's an earlier question that I asked, and I couldn't find the reference there. The proposition I was making was that the timing could be irrelevant. The discussion of the timing could be irrelevant because the indictment was not ready. In fact, it was only ready sometime in December. I couldn't find the reference to it, but I found it now. It's in page 378 in Mr. Hofmeyer's answering affidavit, where he says that in paragraph 220 that Downer proceeded to finalize the indictment. It was finalized on 24 December 2007. And for me, that suggested that their discussion of the timing then is irrelevant because there was no way the indictment could have been served before the 24th of December in any way.
Well, Justice Chiki, two things. I think one draws the inference that as soon as the Polokwane was over and there's the discussion which is referred to that was recorded when they said they've got blood all over their faces, now an egg all over their faces, and the very next day Zuma was charged. And I think if the indictment, it seems, was ready because, as I understand it, there's authority that the poker certificate is only needs to be ready at the time the accused pleads, so you can serve an indictment without it.
Well, what I'm referring you to is what Mr. Hofmeyer says in his affidavit, that in fact it was only ready on the 24th of December, well after Polokwane.
Mr. Epstein, before you go over to costs, There is one thing that did bother me in respect of the legality of the transcriptions. The NIA seems to have suggested, and tell me if I'm wrong, that they'd obtained permission from a judge to intercept telephone conversations of McCarthy. That's the only reference to legality in respect of it. Well, what about the Downer, sort of Downer Soul and all the others? Where is the legality for that? For the interception of those of those telephone calls?
I'm not sure who Downer,
well,
was talking to. If he was talking in the same conversations.
No, there was a discussion between him and Mr. Soul, and then there was discussion between Mr. Casles and someone else, wasn't there? But where is the authority for that?
Justice Neff says, I understand how it came about is as a result of the browse mole leakage and the unhappy of Zima Vavi, a task team was put in place, and that it was because of that the authorizations were obtained. And I won't be able to point you to where those authorizations are, because I don't think they're in this record anywhere except a statement to say that they obtained permission from NIA to use them and release them.
No. That's a different question. That's whether or not Mr. Mshere was in the clear in respect of his use of them. But what I'm putting to you is that I understand it's the Browse-Mole report that sort of prompted this application for authorization, and that the authorization was obtained. But the authorization appears to have been obtained in relation to intercepting Mr. McCarthy's communications.
I don't know. No one else's. I don't know to what extent it was limited. I actually don't. I haven't seen that authorization. I don't think it's in this record.
All right.
I'm afraid I can't.
So if we incline against you, the costs should follow the result.
Yes. All right. Thank you, Jeff.
Mr. Kim.
Thank you, Justices. My co-counsel will move in, if you don't mind, while I address.
Perhaps we should just take a 5-minute break and stretch our legs.
Very well, that will be.
Ja, ek fucking hoor op iets sulke stuk I love the judge. I feel like we should have a roast, and this judge should be.
He should be the roast master.
Yes.
I would love to.
Trying to say something like, but no, dude, you really sound like an idiot. It makes me say it's like,
The shoulder going, and the judge helps put it to the
yeah, it's
and he says, so you're saying this is
to be set aside. What we would accept is that what must remain is the previous decision to prosecute. As a matter of logic.
It's a matter of law and right, and whether we say it in an order which is not really necessary, it would follow as night follows day.
But Justices, if I may say, it seems to me where part of the dispute and issue comes from is that that part has been sort of understood to mean that the previous criminal proceedings that were in the High Court must now just seamlessly on a certain day continue. That is what we say can't be.
So just explain to me, which are you talking about, the indictment and a prosecution based on the indictment that was served?
The submission I make is that those proceedings, the actual proceedings in court, cannot, as a result of this decision, just continue on a day. Something has to be done about it. The indictment has to be reserved or set, something like that.
What about if you got so you're really saying something has to kick-start it, as it were. So whether they give you notice of a day on which the trial will commence, or
Justice Nafsa, what my submission is that as far as Zuma is concerned, the current proceedings, as Mr. Justice Harms referred them to, they are no longer current in the court. That does not mean that the decision of the NPA to prosecute is no longer current. It must be current.
So what you're saying is you might be willing to accept, not that you won't challenge the prosecution once it gets on the ground, because you won't make that concession. But what you're willing to accept is that it could be restarted by way of reserving the indictment.
Yes, but because otherwise it gives rise to all sorts of problems as well. Like, for example, there obviously were bail arrangements in place. Various things happened as a result of a withdrawal.
So what you would really want is reserving all of your rights in relation to the validity of the prosecution or challenges to the indictment or anything else. What you really would like is a formal process so that everybody knows. So let me just understand this, Mr. Kemp. If you accept that the logical consequence is that the decision to prosecute remains extant, which I think you correctly make that concession, what in order for subsequent proceedings to at least indicate a measure of fairness, you'd want to be given notice of when the trial is to start, the indictment, whether it's still the same indictment, and how they choose to do that is up to them.
Yes. Justices, what we have been saying all along, it cannot now suddenly be because the decision underlying the withdrawal has been found wanting, that all the other procedural elements just carry on as if nothing has happened in the meantime.
Mr. Kemp, I just don't want to be a party to further protraction or anything else. Let me just make sure that we're at Eden. You're willing to accept that the logical consequence, having regard to what happened before Msimang, what happened subsequently, Mshia's decision, that for the trial on the decision to prosecute, so perhaps let's just clarify it and tell me if the wording, I won't say appeals to you, but whether the wording has your approval. Not that we're seeking your approval, but whether or not you will be in accord with what I'm putting to you. You accept that decision to prosecute will remain extant, but insofar as the actual trial is concerned, you would want formal notice of when it is to proceed, and you would want the indictment to be reserved anew, and if that is so, all the processes that might follow upon then will then be open to both sides.
Yes.
Is that?
I accept that proposition,
Okay.
Justice Nafsa, because that, of course, there are difficulties, but they will have to be addressed. You will recall that at the stage that this decision of Mshe was made not to continue the prosecution, at that stage, the matter before the Constitutional Court was at the stage where a written argument had to be presented. That is one of the factors that provided some time pressures in Mshe's decision.
Was that the Adams decision that went on appeal?
Yes. We had obtained leave from the Constitutional Court to come and argue the application for leave and the merits. If one looks at in 2009, you will see there's an affidavit from the NPA in the papers, and that deals with their opposition to that application for leave.
Are you talking about Mr. Deploy and others?
Yes. It is just confusing at times, because in 2007, the NPA were busy preparing the affidavit to oppose the appeal on the warrants. So when they talk about...
Are we going back and we're talking about the Farlam, Kluti and the other split?
That is correct. That was what was happening when Mr. Mshe took his original decision.
Mr. Kemp, I'm sorry, I don't mean to interrupt you, but I'm wondering where this excursus is going. I mean, I thought we had agreed if we inclined against the NPA, or National Prosecuting Authority, and yourself on the legality of the decision to not continue the prosecution or to discontinue the prosecution, you accept that what then will remain instead will be the decision to prosecute, but that insofar as the progression of a trial or the initiation of a trial is concerned, you would want procedural aspects to be put in place so that you can then exercise whatever rights you have in relation to it.
Yes.
So far, so good. What does all this other stuff have to do with it?
Well, the following issue that I wish to raise with the court is that if, number one, the decision to discontinue the prosecution was improper because it had not been made under the appropriate legislative power. If that is so, it is our contention that what then must happen is that the representations have to be considered by the NPA, because then they have never done so properly.
I'm sorry, just let me understand this. The representations were made to Mr. Mshe to discontinue, right?
Yes.
You say if he's, okay, so let me say this to you. I don't want to project for you what steps you will take later on, legal or otherwise. I don't think it's within our remit or our crystal ball to do so, okay? All that we can do is make the decision, and once you accept the correctness, well, once what we've agreed upon then falls into place in terms of a decision of this court and an order that follows, the trial proceedings will begin. As to your rights in relation to that, those are not for us to enforce, those are not for us to select, those are up to you. So all of that is up to you. It's not something that we need to pronounce.
Yes, but Justice...
Are you giving us forewarning?
That may be one of the reasons, but it seems...
Let's just understand exactly what you're saying, because I think I know where you're going with this. The first thing is that if we find technically that the wrong section was used, and if that basis alone, which we set aside the decision, then as far as you're concerned, all the representations, all of those sorts of things continue. Correct. Right. If, however, we find, in addition to that, that there are other grounds, for example, that a motive is completely irrelevant to the question of the service of the indictment. So it's not merely on a technical basis, it's on a substantively, the decision is being set aside. Is your position exactly the same, or is it not the same?
Justice Kachalia, my answer to that is, if you find, if this court finds that Mr. Moshe did not make a rational decision,
yes,
then somebody has to make a rational decision on our representations.
So it matters not whether we find on a technical basis or the other. You just want to reserve your position in respect of further challenges.
Yes.
I don't know that we should become involved in that, Mr. Kemp. I mean, that's for you to do. It's for you and Mr. Ali to make the selection as to what you do. We will make decisions as to what the law is and nothing more.
So you effectively want no more than a procedural step to be taken to make sure that the prosecution continues.
What?
In a civil context, you'd want effectively a notice of set down. Here you'd want the summons, the indictment to be reserved, which would have a court date or something of that nature,
yes,
so that the proceedings can then continue. At the moment, if there is nothing.
At the moment, there is nothing. That is our
And what you want is a procedural step to be taken so that you would know where, your client rather, would know where he's got to be and what the defence team wants to do about the prosecution.
That is correct.
And that's all that you need.
Justice Leach, yes, but it seems to me that what my colleague was also trying to ask your guidance on, and you may be quite within your right to say.
Can we mark a brief, Mr. Conk?
Justice Nafsa, you must, in that regard, discount it against whatever interest you have and get out of listening to this debate.
All right. So let's go. Where do you want to go?
What I am firstly saying, and I'll deal with the decision why, and I'll deal briefly with that, and you will understand the parameters of my agreement, of my argument as to why we say that the decision should not be set aside, but it would be very brief. But it seems to me what the NDPP wanted was also to know from this court what must happen if you decide that there was no proper consideration.
Mr. Kemp, let me cut you short. I'm sorry, but if you wish to pursue it, tell me. But it does seem to me that we're asked to adjudicate on one of a number of bases. We will make that adjudication.
Yeah.
We will also say what the consequences are of whatever the decision is. What anybody else does with it subsequently is not our business.
Very well, Justices. The point I simply wanted to make, and I'll make it and then move on, is very simply that the accused, as he then was, had the right to make representations, and he had the right for those representations to be probably considered.
Well, it's really, you're responding to my brother Kachalia, who said, does it matter on what basis?
Yes.
And you say, whatever happens is, if there isn't a proper decision in place, then a proper decision needs to be made, and our representation needs to be taken into account.
Yes.
That seems to be a position you want to reserve.
Yes.
Well, far be it from us to take that away from you.
Yeah.
But that's not what we need to be concerned with.
Very well. Then I will address exactly what our submission is about the wrong section. is the representations were made on the basis that the National Prosecuting Authority had the power to review or to change or to decide to discontinue the Moshe decision to
Well, so you're really making common cause with Mr. Epstein's supplementary heads.
And what I'm saying to the court...
Mr. Kemp, it's not a trick question. Are you making common cause with what Mr. Epstein put in his heads in terms of... Well,
Justice Nafsa, my submission is that as far as the accused is concerned, it is only up to him to put the representations before the NPA, and they have to deal with it. And the one aspect where I will differ with my learned friend is you will have noticed in our affidavit that was filed in this matter that we said, but how you came to these decisions, you seem to have very different versions at different times.
But that seems to be correct. I mean, it does seem to me to be correct, excepting for one thing. In their versions, at some stage, Mr. Mshe is part of the decision-making. At other stages, it's not. It's Mr. McCarthy.
Yes.
But Mr. Mshe is the decision-maker, is he not?
Justice Nafsa, we have always accepted that he at least agreed with the decision, at the very least. But how they deal with our representations and how they make sure that the right person under the right section deals with it, that is for the NPA to deal.
But if they did it wrongly, Mr. Kemp, and that's the issue, and that's what I'm putting to you, and I'm really putting to you the Liebenberg Constitutional Court principle. That's quite clear. You've got to know what power you're acting under. It's more than just, I made a typographical error. I'm sorry, I referred to section 176. What in fact it was 177, and in fact I used the power I had in terms of section 177. If they get it wrong, then the decision can be overturned, must be overturned.
I cannot argue with that proposition. Okay. If I got that wrong, from the third respondent's perspective, we obviously never really knew exactly how their decision-making took place.
I'm not blaming you for their wrongs, Mr. Kemp.
Yeah. Mr. Kemp, if that being the case, is there any basis upon which your side would now wish to defend the decision, Mshe's decision? Is there any basis upon which you say that decision should remain, and then let us know?
Well, may I just make this submission, and it will serve as an answer, and I will then specific in terms answer your question. It was always the applicant Zuma's case that one could never look at that timing charge manipulation on its own. On its own, it doesn't seem to be so egregious. What the argument always was that you should look at all the other things that we have been raising relating to Browsmore, relating to the original decision of Mr. Nuka and Mr. McCarthy to prosecute in 2003, and we said you must look at all those things together.
I understand that, but leave that aside as the second part. In respect of the first part, I mean, I understand the submission that you made initially. And the initial was, well, we also took the position, well, it doesn't seem as if you knew what you were doing. The one, one hand didn't know what the other one was doing.
Yes.
Now, it seems to me that's consonant with the proposition I put to Mr. Epstein, that in fact, they used the wrong section. On their own version, they used the wrong section. Their attempt to distinguish it doesn't help because they're bound by the facts, muddled as they are in their affidavits. So before we get to the second part, which is really the part about whether it was rational and whether all of these other issues, and that doesn't take away your ability to deal with it a la the representations post this hearing, can you defend technically the basis at which this decision was arrived at?
No, I'm not defending that.
So you can't defend that. So what we're at idem about is that in terms of the decision and the technically correct aspects, they erred.
I would accept that, Justice
No,
Nasser.
well, let's go a step further. In other words, they made an irrational decision.
Well, that is then correct, yes.
So your case is not that you want your cake and eat it. It's not that you support the decision, but if that decision is insupportable, then you want to have your representations that you were made dealt with. As I understand your position now, you accept that the decision was irrational and cannot stand, but you still want your representations, account to be taken of your representations.
Yes, and it has always been the case that you, and that is the case that we have always made, that you cannot look in regard to our representations to an isolated fact.
Okay.
Like,
Yeah, but that's for the decision maker.
yes.
Well, could I just ask you this, Mr. Kemp, perhaps you just give me a second to ask Mr. Epstein to be on his feet. Just give me a second for Mr. Epstein to be on his feet. Mr. Epstein, you wanted to listen to whatever ingenious arguments Mr. Kemp may have come up with in respect of the validity of your decision.
Yes,
Before you took an instruction. Well, you've heard Mr. Kemp.
I have. He hasn't added anything which may help me. And while this was the exchange was taking place, I reread Liebenberg, and it's directly against me.
It's directly against.
Directly against.
All right. Thank you. Mr. Kemp?
In that case, I have made it very clear why we contend for that it's proper not to continue the prosecution. But if that hasn't been properly decided as yet, we cannot rely on that decision.
Sorry, let me just say this. If we set it aside and you get notice in respect of what happens prospectively, that I thought you accepted.
Yeah.
You wish to have in the subsequent process your representations to be considered.
Yes.
But then this whole question, I thought you also accepted that insofar as we're concerned now, the issue of judges transgressing into the territory of prosecutors does not arise.
Justice Nafsa, I understand that and I agree with that proposition generally. I do not, in this case, say it arises. What was the problem was that the judgment of a court below was read as if the next day...
As if they're ordering...
that the next day we appear in court and everything goes on as before.
Well, we've now decided that between us, I mean, whether or not, I mean, my brothers and sisters must tell you whether they have a different view. But I, for the moment, don't appear to find anything objectionable with, in principle, conceptually, if we were to say in the body of a judgment, if we inclined against the NPA, that the decision to discontinue gets set aside, that the logical consequence is that the decision to prosecute remains instead, but that in order to facilitate the progression of a trial and such remedies as may be, or such powers and remedies as may be available at the disposal of each party will then be at their disposal. We can't do anything other than that.
Yes.
And that what will be envisaged is that an indictment will be served anew as to when and as well as a date on which a trial will commence. Then you do what you must do, and Mr. Abrams will do what he must do.
Yes, because this court knows now that it's no secret what our stance is, what must happen if our representations were not duly considered. They must be duly
Well, so you're in agreement that we set it aside and that we do what you say should follow in respect of the processes?
Yes.
May I just ask, because it's a bit, the one thing about your representations that are quite unclear to me. You made written representations, correct?
That is correct.
That Mr. Mshe rejected. That they'd made the decision regarding your written representations was that there's a strong case, we're going ahead with it. In addition, you made oral representations. Those oral representations, together with the tapes, seemed quite decisive. But the entire basis of your representations was that going back years now, there's been a political conspiracy against Mr. Zuma.
Yes, that is correct, and
that's the heart of it. Do I understand?
And that is certainly part of it, and what?
No, but it's a critical part of it. Correct?
Yes, it is.
So again, I'm a bit perplexed because that whole political conspiracy motive thesis was rejected by this court in 2009. So where are? Which irons are you keeping hot in the fire now?
Justice Katalia, as I understand the 2009 decision of this court, the point was made that a motive, an improper motive, doesn't render a prosecution wrongful. And we say that if you really read that passage, it further says, well, and you can only work out even if a prosecution is wrongful after it has been done. Those words appear there. So what the court was referring to was like wrongful arrest, wrongful prosecution, etc. We say it is an entirely different issue when matters like permanent stay considerations or policy considerations affecting the prosecution by the NDPP moves him to decide not to continue prosecution. We say those are not similar concepts. They are different concepts. And we have made the point in our heads as well that the discretion to prosecute is not even the counterpart of a permanent stay. You don't have to persuade the NDPP that you have a cast iron permanent stay case for him to decide the game is not worth the candle in a particular.
Well, it's really the Maxwell line of cases, isn't it?
Yes.
But can I just come back to this? So I understand that you and Mr. Epstein now appear to be in agreement that the decision is going to be set aside. Do we need to engage in anything further beyond it once we make that decision and we have a formal judgment that deals with what can be said or can't be said? Do we need to engage beyond it?
No. Because the argument that I want to present, I must then put before the NDPP or not before a court.
And whether it's good or not, and whether or not you're bound by what Justice Haram said, that's an issue beyond argument.
Yes. We did try to take that on appeal, but obviously that appeal...
So sorry, just run that last part, Leon?
We did try to take that on appeal, but that appeal was, of course, ceased as a result of this decision. Because there would be no practical effect on trying to...
Well, it's again something that we don't have to consider.
It's not something. I'm simply giving you the background to understand how certain things came about in this matter. If that is what the court finds, then you are quite right. You do not have to consider the merits of what we say. And the one point that we were putting forward in our heads is that if it comes to a rationality review, it is not correct that a party who's directly affected by that is bound by the version of a decision maker.
No. Well, in relation to what? Because in relation to this particular decision, we've agreed that it's bad and should be set aside.
Yes.
Why are you making these extra submissions?
Justice Nafsa, we don't have to go there on the basis that you've put it to me. Okay. But that was why the third respondent...
Could I just put the following to you? Because I want to make sure that we are not at odds with each other. If we decided that because of what is effectively what the issues that arose in the supplementary heads by Mr. Epstein, that's wrong and that the law is as it is in Leeuwenburg, and we set it aside. Well, it would also go to rationality over and above. Do you accept that?
Right.
Over and above the fact that you can't use the wrong power, it would also be irrational. So
Yes.
we accept. So we club those two together. What the result is of that is that it gets set aside, and that's the end of the matter.
That is the end of it.
What do you say about cost then? Because you came to court seeking to protect the order, or to attack the order, and to have the order of the High Court set aside, seeking an application being dismissed with costs, including the costs on 3 counsel. So what do you say about costs now? If you accept, having come to court to attempt to support the decision, you now concede the irrationality of the decision. Does cost not follow the event?
Yes, Justice Leach, save for the fact that we do point out that whether Section 1795D was applicable or another section was applicable was something always peculiarly within the NPA's knowledge. It depended on how they took the decisions and whose decision it was as to whether, as we know now, it was taken under the wrong section. That was not something that we could control. And the only submission we make about that is, it seems to us that the NDPP said, well, let me try and do it under 1795D because that allows for the greatest input and the less criticism.
Well, what would be wrong with us saying that the two of you are jointly and severally liable for the costs of the DA, and I don't know that they'll get the cost for the entire contingent, but that's a separate issue.
Well, Justice Nafsa, we can only say if we could defend the objective rationality of a decision, we may have been able to do that. I'm not suggesting to you that we spend 2 days in debate when the only implication of that is a cost order.
All right.
But in the light of everyone seeming to have one cost of 3 counsel, would you, if there is a cost order, a joint and several cost order, would it be included 3 counsel?
Justice Leach, it seems.
Or did only 2 of your juniors do anyway?
Yeah. It seems to me that the Constitutional Court generally allows only in very exceptional cases the cost of more than 2 counsel.
Everybody seems to have thought this was a very exceptional case.
You know, Justice Leach, from the debate, it seems that a lot of people thought a lot of wrong things about this matter. But those are the submissions I wish to make.
Thank you. Mr. Rosenberg?
Thank you, Justice North. We have nothing to add in relation to the Berg River decision and the debate that has taken place in that regard, given the concessions that have been made. What we would do is draw the Court's attention to a decision of the Constitutional Court, which we say effectively endorses the dictum of Jafta J in the Berg River case, and the decision in question is Sichal versus the President, RSA and others, 2013-9, Butterworth's Constitutional Law Reports 1091cc. And that is authority which in paragraph 27, which supports the dictum in Berger. So, in the light of the concessions made, it seems to us that no purpose would be served further arguing that.
It's proper, Mr. Rosenberg.
As far as the rationality of the decision is concerned, that appears effectively also to have been conceded, certainly on behalf of Mr. Zuma, and it certainly seems to have been conceded inasmuch as it is accepted that the question of Mr. McCarthy's interference, such as it was on the question of the timing issue, the timing of the service of the indictment, was not a sufficient basis, not a rational basis for withdrawing the charges against Mr. Zuma. The argument on behalf of Mr. Zuma would accordingly appear to be that that decision could only be rational if a whole range of additional material is taken into account, Browse Mole, for example, being the most obvious example, and you have our submissions on that, and it appears to be accepted that the decision itself was based upon a much more confined reason, and it's not permissible or appropriate to go beyond the reasons given in order to assess the rationality.
Well,
so
I'm afraid I think there'll be rounds 2 and 3 and 4 after this, Mr. Rosenberg.
Yes. So for that reason as well, it appears, as we read or understand the concessions made by both of the applicants in this matter, that the rationality of the decision, particularly or in addition, as far as the question of alleged misconduct based upon the timing of the service of the indictment, that too is an insufficient basis to justify or to qualify this decision as being rational.
No, that's not quite correct as I understand it. That's Mr. Kent's concession.
Yes.
Mr. Epstein's concession goes no further than 1795.
Yes.
As far as the timing of the indictment is concerned, that Mr. Epstein's argument is that that in itself was an egregious abuse of prosecutorial power.
Yes. And the court has our submissions on that, and I don't propose to deal with it in any further detail beyond our...
Well, Mr. Rosenberg, I tell you what my problem is, and it's really a legal technical problem over and above the concession that's made. Let me just spell it out for you, and perhaps you can bring me to better insights. And I think it's almost inevitable, and the compelling conclusion is that they just didn't know what they were doing in making the decision. They chose the wrong empowering statute. They're vacillating versions of how it all occurred. For that basis, you knock it out on the Liebenberg principle. That ought to be dispositive. That is wide enough to encompass a rationality review simply because you're looking at all sorts of the wrong things. Now, if you said anything over and above that, for example, if that was dispositive, if you said, but in any event, the basis of the timing, which seems to have been the thrust of it, wouldn't have provided a basis, that may be obiter or it may be an add-on. Does it matter for your purposes? What rounds 2 and 3 occur is not up to us to decide.
It depends upon the approach that the court takes to the matter. We would make the submission that as far as reliance on the timing issue is concerned, for the reasons we've set out in our heads, and I don't propose to take the court through that, the timing issue is not a rational basis for the discontinuation of the prosecution. And we say that for a range of reasons that we've set out in our heads.
Well, if what my brother Kachalia put to you, let's assume, just for the moment, and I don't know what the value will be of the add-on, but if we were to find on the first basis that they used the wrong section, that encompasses rationality, and that in any event they're limited to the question of timing. It's not enough, and that in addition is a ground for setting it aside. Whatever the value of that is not something that we need to be concerned about at this stage.
I must accept that, and insofar as Justice Kachalia pointed out that the concession of the inadequacy of the timing issue as providing a rational basis for the decision wasn't entirely conceded by counsel on behalf of the NPA, I direct the court's attention to our submissions. It's not necessary to go through them as to why we contend, in fact, that timing issue doesn't provide a rational basis. And if the court would like me to go through the submissions on why that is the case...
No, we've debated that extensively, as you've heard.
Yes. And we would submit that, obviously, depending upon the approach that the court takes, it might decline to deal with that as being unnecessary. On the other hand, it might feel it's appropriate to deal with that, and if it does deal with that, we submit for a number of compelling reasons which have been debated in part. It can and ought to be found that the timing issue does not provide a rational basis for the withdrawal of the prosecution.
Yes.
As far as...
How much longer are you going to be, Mr. Rosenberg?
There's unfortunately not much more I can say. But what I would...
We're very pleased about that, Mr. Rosenberg.
What I would like to emphasize is that it appears to be accepted on behalf of Mr. Zuma's team that the consequence of the withdrawal of the charges is that, in fact, or the consequence of the setting aside of the withdrawal of the charges is the original decision to prosecute remains in place. It also appears to be accepted as being an appropriate issue to be dealt with in the order or judgment of this court, to direct that that is the case, and that it would then follow that the following steps normally would involve the reservice of the indictment.
You don't have any, in principle...
We don't have any problem with that. That in fact, it would be salutary for that to be included, so the elements of uncertainty which have been floated around can be cleared up, and so that everyone can be under no misapprehension that it now follows that the prosecution goes ahead in the normal
And whatever
course.
Processes are available to anybody.
That might involve reservice, and as Justice Leach had pointed out, reservice in order to provide for a fresh date for the next or following appearance. Those type of procedural steps can conveniently, it seems, be addressed, at least in part, in the judgment of this court, to clarify the kind of misunderstandings which have been suggested might arise, and which, if possible, ought to be avoided. As Justice...
One wouldn't need to make an order in that regard, though. One wouldn't need to make an order in that regard. It's never been an issue. It wasn't an issue before the court, al quo.
No,
it's not an issue as to what the procedures are, haven't been fully debated before us.
Yes, that is so, and we would suggest that the formulation and approach suggested by the presiding judge in this matter is the appropriate approach, and that's how far it ought to go.
Okay. I mean, all we'll do is we'll probably explain that in the body of a judgment as being accepted by everybody, and everybody will go forward on that basis.
As the court pleases, and in those circumstances we would ask that the appeals get the applications for leave get dismissed with costs. Everybody appears to accept that the costs of 3 counsel are warranted, and our submission it is,
Yes,
given
thank you.
the nature of the matter.
Mr. Epstein, perhaps we can just make sure we're not at odds in relation to exactly what it is that, I mean, it seems both of you have accepted that in relation to the power that was exercised, that is a sufficient basis for setting aside the decision.
That is so.
As I understood the submissions that you were making while you were on your feet when we were discussing the statement by Mr. Mshe and what he took into account, you were intent on presenting an argument that said, well, he did take everything into account. But wouldn't you be pressed to accept that if timing is the only issue, that that's not sufficient?
If timing is the only issue.
If timing is the only issue.
If that's the only issue. But it's what was behind the timing, the purpose of the timing.
Well, that's something that has to be taken into account.
So timing itself doesn't affect the merits, doesn't affect the fair trial.
Yeah. All right. Okay. Well, I mean, I think we can probably circumscribe it on that basis. All right. Is there anything further?
I have no further submissions to make to damage my case any further.
Yes. Okay. Mr. Kemp, nothing further, I would assume?
Justices, if I can just point out, I perhaps did not specifically answer something that Justice Kachalia put to me. I simply will answer that I do not accept that the written representations were accepted. They were all one process.
No, but sorry, maybe we should put to you what I put to Mr. Epstein before. You saying it all has to be taken into account, and when you make the representation, that has to be revisited.
Yes.
But timing on its own is not something that you say.
That is it. No. It was always our case that you have to read it with the other.
Yes.
Thank you.
Yes. Thank you to counsel. Judgment is reserved.